complaint of domestic violence. Domestic violence is a misdemeanor that is punishable by up to 93 days in jail and fines of up to $500. You understand that charge, Mr. Owens?
Yes, I do.
Mr. McCain, do you want any more formal reading?
No, Your Honor, we would waive a formal reading at this time.
And with that, Mr. McCain?
Yes, Your Honor, Jefferson McCain appearing on behalf of Mr. Owens for the limited purposes of arraignment. We have reviewed the charge and complaint and, like I said, waive its formal reading. Mr. Owens is entering a not guilty plea today. Mr. Owens does qualify for a court-appointed attorney, and we would request this matter be set for pretrial and trial, Your Honor. Thank you.
Thank you, Mr. McCain. Mr. Owens, the court will be entering a not guilty plea on your behalf, sir. The public defender has determined that you are indigent, meaning that you will have legal representation at public expense. This matter, I'm sorry, got a frog in my throat. This matter will be set for a pre-trial conference with the prosecutor, and if you're unable to reach a resolution, then jury trial will take place here in courtroom D. Court staff will mail to you paperwork. What is your mailing address?
1546 112th Avenue, Sego, Michigan 49078.
Thank you. Mr. Owens, you were released on a $500 personal recognizance bond. That will continue moving forward. Your bond conditions include a prohibition on any contact, whether it's direct or indirect, with a Taylor Owens. You know Taylor?
Yes, she's my wife.
Okay, and you understand the difference between direct and indirect contact?
Yes, Your Honor.
Okay, and not only are you prohibited from direct or indirect contact, but you may not go to where she lives or works. You may not engage in any assaultive, abusive, or threatening behavior. You may not consume any alcohol or other controlled substances. You may not possess a firearm or other dangerous weapon. You have to attend all future court hearings. You may not leave the state of Michigan without permission, and you need to notify the court of any change of address or phone number. You agree to all those bond conditions, Mr. Owens?
Yes, I do, Your Honor.
All right, anything additional on this file, Mr. McCain?
No, Your Honor, not at this time.
Thank you. Good luck to you, Mr. Owens.
Thank you.
Everybody else is in the court.
Okay. Ms. Johnson, can you hear me?
Yes, sir.
All right. This is file 253717 FY People of the State of Michigan versus April Johnson. We're here on a single count felony warrant for larceny in a building. Larceny in a building is a felony level offense that's punishable by up to 4 years in prison and fines of up to $5,000. Ms. Johnson, do you understand the charge and the possible consequence?
Yes, sir.
Mr. McCain.
Jefferson McCain appearing on behalf of Ms. Johnson for the limited purposes of arraignment. We have reviewed the charge and complaint and waive its formal reading. Ms. Johnson does qualify for a court-appointed attorney, and we would request this matter be set for probable cause conference and a preliminary examination. Thank you, Your Honor.
Thank you, Mr. McCain. Ms. Johnson, the court will be entering a not guilty plea on your behalf. The Public Defender's Office has determined that you are indigent, meaning that you will have legal representation at public expense moving forward. Your attorney has demanded a preliminary examination. That will take place within 2 weeks. First, your probable cause conference will take place on December 18, 2025, and that will be 1 o'clock in the afternoon on Zoom in courtroom A. The following week, December 22nd, 2025 at 9 a.m., your preliminary examination will take place. That examination is in person here in Allegan in courtroom A. Court staff will mail to you paperwork. What is your mailing address?
628 Fairview Ave, Northeast, Grand Rapids, Michigan, 49503.
Thank you, Ms. Johnson. Your bond was set at a $1,000 cash surety bond, which you have posted. That will continue moving forward, as well as your bond conditions. And those bond conditions do include a prohibition on leaving the state without permission. You have to attend all future court hearings, and if you change address or phone number, you need to notify the court. Do you agree to those bond conditions, Ms. Johnson?
Yes, sir.
Is there anything additional on this file, Mr. McCain?
No, Your Honor, not at this time.
Thank you, Ms. Johnson.
You're welcome.
Have a good day.
You too.
Thank you. Is everyone else just on phone? Okay. Mr. Minton, are you present?
Yeah. Yes, sir.
Okay. This is file, can you take your hood off, please, sir? You're in court. Thank you. This is file 253971SD, people of the state of Michigan versus DJ Minton. We're here on a single count misdemeanor complaint. Mr. Minton, you are charged with operating while intoxicated second offense. Operating while intoxicated second offense is a misdemeanor that's punishable by between 5 days and 1 year in jail, as well as fines of up to $1,000. Do you understand those charges, Mr. Minton?
Yeah.
And with that, Mr. McCain.
Jefferson McCain appearing on behalf of Mr. Minton for the limited purposes of arraignment. Mr. Minton has notified me that he intends to Mr. Minton has informed me that he intends to plead not guilty today. He, however, does not qualify for a court-appointed attorney, but would request this matter be set for pre-trial and trial, Your Honor.
Thank you. And he does not qualify due to income requirements? Is that correct?
Yes, Your Honor.
Okay. Mr. Minton, the court will be entering a not guilty plea on your behalf. The public defender's office has screened you and determined that you do not meet the indigency requirements, and as such, you will not be entitled to a public defender. That means that you will either be representing yourself or you will need to hire or retain an attorney of your choosing. Do you understand that, sir?
Yes, sir.
All right. This matter will be set for a pretrial conference with the prosecutor's office, and if you're unable to reach a resolution, then jury trial will continue here in courtroom D. Court staff will mail to you paperwork. What is your mailing address, Mr. Minton?
625 Strawberry Lane, Muskegon, Michigan.
49442?
Yeah.
All right. So with that, Mr. Minton, your bond will continue at the $500 personal recognizance bond, which was previously ordered. That means that while you're on bond, you may not use any alcohol, marijuana, illegal drugs, or other intoxicating substances. You may not leave the state without permission. You need to attend all future court hearings. And if you change address or phone number, you need to notify the court. You agree to following all those bond conditions, Mr. Minton?
Yes, sir.
All right. Anything additional on this file, Mr. McCain?
No, Your Honor.
Okay. Thank you, Mr. McCain. Good luck to you, Mr. Minton.
Thank you.
Thank you. That's it. Okay, Mr. Shaw, are you present?
Yes, sir.
This is file 253980SD, people of the state of Michigan versus Edward Shaw. Mr. Shaw is here on a single count misdemeanor complaint of operating with a high BAC. Operating with a high BAC is a misdemeanor that's punishable by up to 180 days in jail and fines of up to $700. You understand the charge, Mr. Shaw, and the possible consequence?
Yes, sir.
Okay, with that, Mr. McCain.
Jefferson McCain appearing on behalf of Mr. Shaw for the limited purposes of arraignment. Mr. Shaw and I have read the charging document and waive its formal reading. Mr. Shaw has told me that he intends to plead not guilty today. Mr. Shaw does qualify for a court-appointed attorney, and we would request this matter be set for pretrial and trial, Your Honor. Thank you.
Thank you, Mr. McCain. Mr. Shaw, the court will be entering a non-guilty plea on your behalf. The Public Defender's Office has determined that you are indigent, meaning that you will have legal representation at public expense moving forward. This matter will be set for a pre-trial conference with the prosecutor. If you're unable to reach a resolution, then a jury trial will take place here in Courtroom D. Court staff will mail to you paperwork. What is your mailing address?
118 Roth Street, ROTH, Southeast Grand Rapids, Michigan, 49548.
Okay. Mr. Shaw, you were released on a $500 personal recognizance bond. That will continue moving forward. Your bond conditions prohibit the use of any alcohol, marijuana, illegal drugs, or other intoxicating substance. You may not leave the state of Michigan without permission. You must attend all future court hearings, and you need to notify the court of any change of address or phone number. Do you agree to all of those bond conditions, Mr. Shaw?
Yes, sir.
Anything additional on this file, Mr. McCain?
No, Your Honor, not at this time.
All right. Good luck to you, sir.
Thank you very much.
And then which one is going to be the plea? Is the guy dying? Let's do White then really quickly.
Yes, sir.
Mr. White, are you present?
Yeah.
This is file 253995FY, people of the state of Michigan versus Jason White. Mr. White, you're here on a multiple count felony complaint. Count one is carrying a concealed weapon. That is typically a 5-year felony, as well as fines of up to $2,500. Count two is possession of ammunition by a prohibited person. That is typically a 5-year max felony and fines of up to $5,000. And both of those are mandatory forfeiture of the weapon or device. Count three is open container in a vehicle. That is a misdemeanor punishable by up to 90 days in jail and fines of up to $100. Count four is a misdemeanor. It is operating with a suspended license. Again, misdemeanor level offense punishable by up to 93 days in jail and fines of up to $500. However, the prosecutor has indicated that you are a fourth offense, habitual offender. So what they would do is it could enhance the maximum penalty for the felonies. And so the underlying felonies are 5-year max felonies. With the enhancement, those would turn into life in prison felonies. Do you understand the charges, Mr. White, and the possible consequences?
Yeah.
With that, Mr. McCain.
Yes, Your Honor. Jefferson McCain appearing on behalf of Mr. White for the limited purposes of arraignment. He and I have reviewed the charging complaint and waive its formal reading. Mr. White does qualify for a court-appointed attorney, and we would request this matter be set for a probable cause conference and preliminary examination. Thank you, Your Honor.
Thank you, Mr. McCain. Mr. White, the court will be entering not guilty pleas on your behalf. The Public Defender's Office has determined that you are indigent, meaning that you will have legal representation at public expense moving forward. Mr. McCain has demanded a preliminary examination that must occur within 2 weeks. First, your probable cause conference will take place on December 18, 2025 at 1 p.m. on Zoom in Courtroom A. Your preliminary hearing is December 22nd, 2025 And that will be in person, also in courtroom A at 9 a.m. You understand the times, Mr. White?
Not on the second one. What's the 1222 for?
That is the preliminary examination. That's the one where the prosecutor needs to establish probable cause.
Okay, so what's the 18th for?
That's the probable cause conference. That's where you'll talk to your attorney and you'll figure out what you're going to do, whether you're going to run that prelim or not.
We run it all.
All right? If you have additional questions, you can ask those to Mr. McCain.
All right.
You understand the dates the court gave you, though?
Yeah, sure.
All right. The court staff will mail you paperwork. What is your mailing address?
508 West Van Buren.
Thought maybe that would be something that y'all should know.
Yeah, well, I appreciate that. That helps. Wow, I'm
Judge, why don't you support him and go buy a car from him, his first sale car?
Yeah.
Please.
That would be good
I'm looking
support.
for it.
Yeah.
If I hadn't already bought one before the fall here, I'd have taken you up on it. How's that?
We do oil changes too, so.
Oh, shoot. Yeah. I just bought an EV, so that's not going to help me on that one.
Okay.
That's going to be a
Well,
little tougher. But
that's
you
fair.
can keep plugging away. I'll keep you in mind. How's that?
all right, sounds good.
All right. It looks like this is the first alcohol-related offense too, so which helps. Let's see, you got it. Oh,
I'm
self-employed.
planning on it being my last too, so.
Good.
Yeah, good. I don't want to hear from him again.
And it looks like, Mr. Ewing, help me out with it looks like there was no jail time. Was there an accident? I guess I didn't look.
So he reports that he pulled over because he was sleepy and whatever. He hit a sign in someone's yard. I don't know if there's a restitution request. I don't know how bad the damage was. I didn't see any photographs.
Yeah.
And you did go to, were you in jail overnight, correct?
It was mainly just while they were getting the whole like paperwork and stuff like that done. I sat in it wasn't like a jail cell necessarily, but it was like I guess you could probably call it a cell.
How long were you in the jail building?
Yeah.
Overnight, released in a few hours?
Was it like
a
from
few hours, pretty much.
few hours?
Yeah.
Mr. Ewing, I don't even know the time on that. I'm trying to find something here. Was it, you think there
It
was?
was at
2
3
days like-
a.m. So if he was only there for a few hours, he probably only has 1 day credit.
Okay, all right. So we'll order 1 day jail credit for 1 day. Hold in advance 92 days jail. Order, I'm not going to place you on probation. Trusting it's going to be an isolated case for you. The fine is probably the biggest thing out of this. $1,000 fine and cost or 90 days jail. Plus symposium on substances programs, 1 day program. And Mr. Ewing, just to clear things up, I'll just put plus restitution, if any. If for some reason there's some type of restitution and it's not reasonable, we can always set it for a hearing, but I'm just putting just to cover it. So we can cover it. We'll set show cause hearing date for, let's use that May date, May 15th. May 15th, 14th, May 14th. At 8:30, it'll be back on Zoom, sir. So we'll just do that. Just make reasonable payments for me, and then get that program in for me, okay? Now I'll take care of it. All right?
Thank you, Judge. I appreciate it.
You're welcome. Good luck to you. Good luck in that new job.
Well, thank you. I appreciate it.
All right. Bye now.
Have a
You and
good day.
thanks. You too.
Am I okay to leave?
Oh, you are. Yep. I was just going to get you off too. Yeah, just disconnect. You're all set.
All right,
Your
sounds
Honor,
good.
is it,
There, Your Honor.
Okay.
Good morning, Your Honor. Is it possible to put me in a breakout room with the Vienna Township prosecutor on
Yeah.
Linwood Stokes?
Sure, on Stokes. I had
Yeah.
your file sitting here too. Yeah, Linwood. Put you back in with Mr. Strip Matter. I'll do it right now for you.
Thank you.
Yeah, thanks. Appreciate you asking. That kind of helps move things along too. So
No problem.
how about Gerald Nims? Mr. Nims.
Good morning, Your Honor.
Guy. And who I got for Mr. Nims? I've got Mr. Bigger on the file, but
Yep. Michael
oh, there,
Taylor.
Mr. Taylor. Mr. Taylor, let's see. We set today's date for pre-trial. Did you get a chance to talk to the prosecutor?
Yeah, Your Honor, the prosecutor made an offer on the case. We're requesting just a couple of additional pieces of discovery that they're agreeing to look into for us. So we're just asking for another pretrial date. We think we'll have a resolution or plan by then.
Okay. Let's see. We're set for. When's our next pretrial? Are we after
January
8th? How about January 8th?
Perfect.
All right. 8:30. Be back on Zoom.
Thank you.
Thank you,
Yeah.
Mr. Taylor. Mr. Nims, good luck to you. Candace Keels.
Good morning, Your Honor. Harold Milhouse on behalf of Ms. Keels.
Mr. Milhouse, and let's see, I think I saw Ms. Keels at one point here. Got her still or not?
She was there, Your Honor.
Oh, yeah. Yep, I got her. Yeah, she's coming in right now. I had her separate out to keep track of her. She's coming in.
Okay. I haven't had a chance to speak with the city attorney or the prosecutor, and I'm
Okay.
asked that give us a chance, and I'll request the discovery, take a look at it, and have us back for another pretrial.
Okay. He is set for an arraignment too. Ms. Keels, are you there? Candace Keels? Just have to unmute now. Oh, she just. There you go. Are you
Yes.
there?
Yeah.
Okay. You're being charged with resisting obstructing a police officer. Carries a penalty of up to 93 days in jail and a fine of up to $500. Also being charged with carrying open intoxicants in a motor vehicle. Carries penalty of up to 90 days in jail under a fine of up to $500. It's also a civil infraction ticket for careless driving. That carries a penalty, fines, and costs. Do you understand these charges?
Yes,
Okay. And did you hear the rights that I went through at the beginning?
I wasn't in the chat.
You weren't?
No.
Okay. You have the right to have a trial in this matter, at which time you have the right to have a trial before a judge or a jury. You have the right to act as your own lawyer, hire a lawyer to represent yourself. If you decided to plead guilty, you'd also have the right to have a lawyer present at the guilty plea. If you cannot afford a lawyer and you're eligible, the court would appoint one for you. You have the right to subpoena, call witnesses of your own at trial. You have the right to confront and question under oath any witnesses called against you. Also have the right to testify at trial or not to testify at trial. If you decided not to testify at trial, would not be held against you. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes,
Okay, so I'll enter a not guilty plea. Mr. Milhouse, on these matters. And are you retained?
Yes, I am, Your Honor.
Okay. Set a new pretrial date for 8th. I guess I have to write it down. I keep reading the January 8th at 8:30.
Good morning, Your Honor. Alexander, on behalf of the people, Your Honor, the people waive any potential conflicts between this honorable court and the office of the public defender. If such a conflict exists, the people make this waiver points.
Assistant Public Defender Chinazi Carey Kimberly. Good morning, Your Honor. On behalf of the Public Defender's Office. On behalf of the Public Defender's Office, Your Honor, we also do not believe that a conflict exists. If this court were to find that a conflict exists, we waive that conflict.
And the court, for its part, also does not believe there's a conflict either in the Michigan court rules or the case decided there under. To the extent conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Devin Lyons Nash.
Kenneth Overwater, Assistant Prosecuting Attorney.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Lyons Nash. Mr. Lyons Nash, could you state your name for the court?
Devin Jeremy Lyons Nash.
Got it. Okay. I have before me a plea form that indicates that the defendant would be pleading to count 2, a joyriding first offense, which is a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also the prosecutor will recommend that the defendant be sentenced as a first offender pursuant to the statute.
That's our full understanding, Your Honor.
That's correct, Your Honor.
All right, very good. Sir, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall help you God?
Yes, sir.
State your name again for the record, please.
Devin Lyons Nash.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of joyriding. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand all of that, sir?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge
Perry.
Judge Perry in the 15th District Court.
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Did he do an advice right?
Your Honor, I did submit one to the court that he authorized me to sign with his permission.
Okay, you went through an advice of rights form with your attorney?
Yes.
Gave him permission to sign that?
Yes.
All right. Do you have any questions regarding any of those rights?
No, sir.
Under paragraph 5, you understand that those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form. You understand that, sir?
Yes, sir.
All right. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 1st, 2024, at the location of 2771 Plymouth Road, City of Ann Arbor, Washington County, State of Michigan. What did you do involving a vehicle belonging to Lansing Kita that makes you think that you're guilty?
I drove away without her permission.
All right. Bunch does it. Sir, I do have to advise you that if I accept your plea, and if between the time of your plea and the time of your sentencing you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the defense, Your Honor.
None from the people.
And have I complied with the court rule, and would it be proper to accept this defendant's?
People are satisfied, Your Honor.
And the defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 2nd at 8:30.
January 2nd, 2026, 8:30 before Judge Perry. Bond in this matter will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Daniel Cummings.
Andrew Children's attorney on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cummings, who is approaching.
Your name, sir?
Daniel Cummings, Judge, Your Honor.
Your Honor, I do have a green sheet. We are requesting an adjournment. We are going to refer Mr. Cummings to the Veterans Treatment Court. He does live out of county, so
Gonna take a minute.
Redford.
Would you be able to get that accomplished by the 30th, or you need more time than that?
Thank you. We can try. See where we can get.
Probable cause conference will be adjourned to December 30th, 2025, 9 a.m. Bond will continue.
Your Honor, Mr. Cummings would like me to address bond.
Briefly.
Your Honor, Mr. Cummings is requesting a personal bond. He is currently in custody with significant medical issues. As you can see, he wears a brace. He has to wear that 24 hours a day. He about a year ago received a back surgery with that involves getting 14 rods in his back. He has to sleep in a certain type of bed, which obviously is not available here in the jail. He also has cystic fibrosis, so he has to wear a vest to shake his lungs. He cannot use that in the jail. He also uses a nebulizer, but he cannot use that in the jail. He's on about 18 different medications, and he cannot receive most of them while in custody.
For my bone deterioration.
His osteoporosis, he says he receives a shot
Every day.
Every day, cannot receive that in the jail. So these things are accumulating. He is relying on one lung to breathe as one of his lungs is collapsed. So he's really struggling.
That doesn't account
medically.
for his fentanyl use, does it?
No, it doesn't, Your Honor, but
I know, and that's the reason that you're in and why I revoked your bond.
Right.
You can continue, Ms. Perry, briefly.
You know, I think Mr. Cummings, this is his first offense, his first time being on bond, his first time ever drug testing, doing anything like this. I think he's really learned potential consequences of his actions. He's been incredibly remorseful to me every time we've spoken, and I think he's incredibly willing to commit to any bond conditions the court may order. He's discussed testing every day and home confinement. He really wants to get home to his wife who has Alzheimer's. He's just really struggling.
may I say something, Judge? Please. I'd like to address, I want to say thank you for locking me up. It allowed me to get off of drugs, and I feel my mind is clear, my body's clear. I feel fine. I have no urge to, this kind of place is not for me. I've never been, don't have a criminal record. I've never been in jail. Only thing I did, well, you know what I did, and I just need to get home to my wife and my medicines. Otherwise I've had MRSA, I've had pneumonia, but that's what's happening. And I need to lay in a certain bed, an incline bed, or my surgery is not going to hold. I got 13 bars in my back, and I will do anything
I'm
and
sure
everything.
Talk to the jail medical personnel, though, accommodate you in the best way that they possibly can.
They can't. They said they can't give me these medicines. Can I be under a house arrest?
Anything else? This isn't a negotiation, but anything else?
You mean I have to stay in jail?
Anything else?
I'm not sure what's going on.
I've listened to you, counsel. I've listened to you.
I'm gonna end up getting sick in here, sir. And can I just be under house arrest? I won't go nowhere.
Sir, we gave you bond conditions. You violated those bond conditions. I revoked your bond because of that. There isn't a medical reason for those drugs that were in your system. You shouldn't have been using them anyway if you suffer from as much as you suffer from at this point in time. And so.
Well, I was addicted, and when they said come in for the Washtenaw corrections, come even if you're dirty, and then we'll help you detox. Okay. All right. Well,
I don't need a response. If people motion for bond reduction is denied, bond will continue as revoked. Thank you. Court does call the case of the people versus Edward Byrne. Come on, people. Where's Miss Cannon? Yes, the AG's here. Miss Cannon is not. AG, you can put your appearance on.
Christina Beta on behalf of the Attorney General's office, Your Honor.
Good morning.
Good morning.
Where is she?
Your Honor, right here. I'm just trying to get through the door. It was a
You just
juggernaut
needed to
right
use
here.
your elbows. All right.
My apologies, Your Honor.
Some burns.
Thank you. Your Honor, as it relates to Mr. Burns, Mr. Burns has filed a copious amount of
You wanna
paperwork
state
and we're
your
just
appearance?
asking, yes, Stephanie
wanna
Cannon on
state your-
behalf of Mr. Brandhouse.
And is Mr. Burns here?
Yes, Your Honor.
State your name.
Manuel Barnhouse.
Wait, did you call Brandhouse or Byrne, Your Honor?
I called Burn.
Mr. Byrne, are you present? Mr. Byrne, please be present. Your Honor, Mr. Byrne, we are asking for an adjournment of his case. He is supposed to be appearing by Zoom. He does live in a different state, so I'm just not sure if the time difference has. Can I call him and get him present by Zoom? We spoke
No,
yesterday.
we'll probably wake him. He's out west.
I'm just,
I don't know that.
yes, I'm just asking, Your Honor. He's
No,
supposed
I'm
to
not
appear by.
asking. I got
I understand, Your Honor. Then I would just ask for an adjournment of the matter.
bench warrant will issue for defendant's failure to appear bond. How much is owing in child support at this time? Madam Attorney?
It was around 14,000, I believe, if I'm not mistaken. Is that correct?
I believe so.
15,000 and he posted 27. He posted about a quarter of what was owed at the time.
And he's made several payments since then.
Bond, bench warrant will issue. Bond will be set at $10,000 cash to be applied to the child support case.
Thank you, Your Honor.
Thank you, Your Honor.
That warrant will issue immediately. Thank you. Court does call the case of the people versus Kurt Bushline.
Good morning, Your Honor. J. Grant Miller approaching the podium with Mr. Bushline.
State your name.
Kurt James Bushline, sir.
All right, what?
Your Honor, I was speaking with the people this morning and we are requesting a brief adjournment to see if we can't negotiate out a universal settlement with the matter with Gratiot County as well.
Probable cause conference, December 23rd, 2025.
23rd, thank you, Your Honor.
9/8, bond.
Thank you, Your Honor.
Court calls the case people versus John Brooks.
Good morning, Your Honor. Michael Vincent on behalf of Byron Taylor. Excuse me, John Brooks.
Your name, sir?
John Brooks Senior, Your Honor.
All right, go ahead.
Your Honor, Michael Vincent on behalf of John Brooks. He is here on probable cause assault with intent. And he also has third offense drunk driving.
Okay, and you're looking to,
we need an adjournment because we just, literally got retained a couple days ago.
23rd or 30th, which will work. Hello?
I'm helping, Your Honor, sorry. The 30th or just fine.
Probable cause conference in these matters will be adjourned December 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Yes, sir. Court does call the case of the people versus Frank Green.
Can you be a wheelchair? Okay, yeah. Good morning, Assistant Public Defender Warren Kearney on behalf of Mr. Green, who is in custody, Your Honor. He may be in a wheelchair, so they may be slow rolling. Thank you.
Not even responded.
All right.
See you back there?
A walker, sorry. Mr. Green, state your name for the record when you.
Frank Henry Green.
Thank you.
Your Honor, we are requesting an adjournment. Mr. Green is in felony drug court and we're going to refer him on this case as well, I believe. How you doing?
Getting signed off to treatment.
Probable cause conference adjourned December 30th, 2025, 9 a.m.
Okay, now
Bond will continue.
go over the.
Thank you. And so that you know, I did approve his release.
Thank you, Your Honor.
To jail. Court does call the case, People versus Ron Moore.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Come on up to the podium, sir.
Your Honor, Michael Vincent, on behalf of LeBron Moore, state your name.
LeBron Moore.
You're requesting an adjournment for additional discovery.
Yes, I also would like to address bond condition. I've talked with community corrections with his mom. His uncle is disabled in a wheelchair. We'd like to get the court's permission for him to leave his house, take care of his uncle from 7 a.m. to 7 p.m. I've seen pictures of him. His uncle is in a wheelchair. His mother specifically
I'm adjourning this to the 30th. Frankly, I'll let the people respond, but frankly, he's here on a life of capital offense punishable by life. I'm very reluctant to change bond, just give him 12 hours to be out wherever. Frankly, I'm not sure why he's out.
He has a very, very skilled attorney, Your Honor.
Understood.
Good morning.
But not that skilled today. Motion for bond modification is denied.
All right.
Bond will continue. Thank you.
Thanks.
Court does call the case, People versus Joseph Griffin. 4 cases.
Trevor Mayville, People.
Good morning.
Good morning, Your Honor. James Fefelski on behalf of Mr. Griffin on the case ending in 1698.
Assistant Public Defender Appleton on behalf of Mr. Griffin on the remaining 3 files. Mr. Griffin, will you state your name for the record?
Joseph Bertrand Griffin, Your Honor.
All right, what are we doing?
Your Honor, it's my understanding Mr. Griffin wishes to waive preliminary examination on all of his files. Can you sign this, please?
Yes, sir.
That is correct, Judge. I did provide the court with the waiver on the 3 files of the PD office.
And I've got mine here.
That one, I don't have the other.
Please sign it. Thank you.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor. Yes, sir.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on all felony counts with the misdemeanor counts following.
Your Honor, we waive formal reading. My client would stand mute at this time.
Your Honor, I'll waive formal reading on my file as well. He'll stand mute on that charge as well.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial will be set for
January 5th at 1:30 with Judge Oda.
January 5th, 2025, 26, 1:30 before Judge Hammoud.
Yes, sir.
Bond will continue.
Thank you very much, Your Honor.
Thank you.
Take care of yourself.
Court does call the case of the people versus Byron Taylor.
National Health for the people.
Your Honor, Michael Vincent on behalf of Byron Taylor. State your name. Byron Taylor.
All right, you're requesting an adjournment, requesting.
We've changed our mind. We've adjourned this a number of times. We need to move forward on a prelim exam with the court.
You'd like to set for preliminary examination. It's all discovery then complete.
I have everything that have been provided.
People have their witnesses available the 23rd.
We'll try, Your Honor.
Preliminary examination in person will be set December 23rd, 2025, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond continue.
Thank you.
Thank you. Court calls case People versus Jonathan Hughes.
Andrew Childers appearing on behalf of people.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Hughes, who stands to my right. Please state your name.
Jonathan Hughes.
Your Honor, I was late appointed last night. I apologize if the order was signed.
It was signed.
Okay, I apologize. I just received the discovery from the prosecution. I'll go meet with my client. We'd like to just set this on track to the hearing. Simple possession. He wants his day in court.
He wants a preliminary exam set without you reviewing discovery.
Yes, Your Honor.
Is that right, sir?
No.
I have started to look for it, and we'll meet with him this afternoon.
From the people, all discovery has been sent out, though.
I sent all the paper discovery 10 minutes ago.
And I've opened my email and acknowledged that I have received the discovery, Your Honor. I was sent.
People have their witnesses available the 23rd.
That's fine, Your Honor.
Preliminary examination, December 23rd, 2025, noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus Tabitha O'Carroll.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Ms. O'Carroll, who appears via Zoom.
O'Carroll, can you unmute and state your name, please? Okay, you can talk, but you need to be unmuted. The one with the microphone. You just did it, and there you go. What's your name?
Tabitha O'Carroll, Your Honor.
All right, you're requesting an adjournment on this one?
Yes, Your Honor. If we could just put it over for a week, I believe we're going to have a plea.
That's not going to happen. She's out of custody.
Yes, Your Honor.
December 30th, 2025, 9 a.m.
Yes, Your Honor. Thank you.
Thank you, Your Honor.
Court calls case of People versus Brian Laster.
Andrew Childers appearing on behalf of people.
On behalf of Mr. Laster, Your Honor. Guys, you need to stand on the side, please. Stand up here.
Excuse me, but can you let me know what the reasons?
Give me 1 second, Mr. Laster. Your Honor, we are asking for an adjournment in this matter. When I attempted to visit with Mr. Laster yesterday, he informed the Sheriff's Department that I was not his attorney and did not speak with me.
I have not had the opportunity to talk to him about his case, but I am your attorney, Mr. Hudson.
It was,
Um,
okay.
I promise you,
I don't, okay, promise, promise.
I promise I'm your attorney.
December 23rd, 2025, 9 AM.
Can you let me know what the charge is?
Yes.
If you are mine.
I'm gonna try and get somebody to talk.
Bond will
Yeah.
continue. Thank you.
Can we address the court before I leave here? What the charge is?
Your Honor, my client
I've been
wants,
asking, I've asked around 15 times. So,
what you're charged
yeah,
with?
it's, I have no paperwork or nothing. What the charges are? If you know, can you just let me know before I enter anything?
Your Honor, my client, he doesn't know what the charges are. And again, I would have gone over this
He
yesterday.
doesn't know what the charges are. Were you paying attention at your arraignment?
It was some, today was 11. I got recurred back at, for 18th, court date. And then.
Well, let me just
I
go
was
this
told-
way, sir. If you don't understand the charges, you're before the court on a complaint that alleges that on or about September 20th, 2025, location of 410 West Huron Street in the city of Ann Arbor, Washtenaw County, that you did knowingly and intentionally possess less than 25 grams of a mixture containing a controlled substance of cocaine contrary to Michigan statute. Do you understand what you're charged?
Oh, yeah, okay, that was a
Okay,
substance.
no,
Yeah, the substance.
That's a felony punishable by 4 years incarceration and $25,000 fine plus court costs.
Okay, well,
Which
it's
is the maximum
a
penalty,
substance
sir.
found. Yeah, I was told when I got in
Okay,
the car, it was a substance found.
Mr. Laster, listen,
Substance, man, is that the
I
same?
need to, yes.
Is that the same?
That's the same thing. Substance, yes.
I had a vial with. the
Okay,
crack-
don't
with the
talk about
crack in it.
anything, Mr. Laster, please. I'm going to talk to you. You just have to talk to me and I'll explain everything, okay?
I never had that.
I understand.
Controlled substance.
I understand. You have to go back, but I will talk.
Fine will continue.
Okay.
Thank you. Court does call the case of the people versus Delisa Robinson.
Good morning, Your Honor. J. Grant Miller, G58658 on behalf of Delisa Robinson, who should be on Zoom. We have been texting since about 7:02 a.m. And unfortunately, I believe I forgot.
Delisa Robinson? Not here.
Your Honor, I cannot locate my phone. I don't know if I left it at the office this morning, so I have no way to contact her directly, and I apologize to this court.
Bench warrant will issue for defendant's failure to appear, bond $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Court calls case of the people versus Charles Hudson.
He's in the back.
Christopher Coyle, P 49708, appearing on behalf of Charles Hudson, who's approaching the podium. Mr. Hudson, when you get to the podium, can you state your name for the record, please?
Charles Hudson.
Charles, louder.
Got it. I got it.
Okay, thanks.
Go ahead. What are we
Judge,
doing?
we're going to set it for a preliminary examination this morning.
All discoveries complete.
Yes.
People have their witnesses available the 23rd.
I will not be.
Can we set it for the following Tuesday, the 30th?
I certainly can. Will that work?
Yes, sir.
Works for me as well. Thank you.
Preliminary examination in person will be set for December 30th, 2025. 9 a.m. or 12.
Judge Washington.
9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case, people versus Rayshawn Dawson.
James Fifelski on behalf of Mr. Dawson. Dawson? Where'd you go? Mr. Dawson? I did speak to him, Your Honor. He's probably in the.
I'll pass it. We'll call it at the end of the 200. Court calls the case, people versus Procopio Vitale.
Special Phillips for the people. Good morning, Your Honor. For Yagi Assistant Public Defender with and on behalf of Mr. Vitale. Mr. Vitale, could you state your name for the court? Oh, I'm sorry. Losing it. I apologize, Your Honor. I do have a green sheet for this matter.
You're looking for an adjournment?
I am.
Will the 30th work or the 23rd? Which would you prefer?
No preference, Your Honor.
Probable cause conference will be adjourned December 23rd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls the cases of the people versus Michael Donner.
Alexander on behalf of the people.
James Fefelski on behalf of Mr. Donner, who is approaching.
Michael Donner is present.
Your Honor, please briefly approach.
You may.
Yeah.
Anything with regard to bond, Mr. Milhouse?
Your Honor, I think she's been following the terms of conditions that's been set, and she's not a flight risk. And she'll show up in court, and so I believe she's out on a PR bond, and ask that they continue.
Okay, they get her on something. What's that? If there's not.
Calls to the victim that were completed and 8 attempts to call the victim. It is my understanding now that after he was released, as recently as yesterday, his truck was placed at her address with his home, and he was seen by Northfield police officers leaving the home where he's not supposed to be. So at this time, based on my original motion and these new flagrant bond violations, I would ask that he be remanded and his bond be set as revoked, given that he violated his bond originally with jail calls and now being at the no-go-to residence that he was not supposed to be at. I also have concerns given that his bond was originally set at $100 or 1,010%, and he was not given a GPS tether. And this case was picked up while he was on bond for a different case. Now that case has been disposed of and he was found not guilty on that case. But at the time that this case arose, he was on bond conditions for that case. So I have concerns that his bond was originally set so low and that he was not given a tether, and then he leaves jail after violating bond and continues to violate bond.
Your Honor, in context, this is the marital home. Ms. Ryan and my client are married. They have 5 kids. My client is the sole breadwinner. Yes, he had 2 phone calls with Ms. Ryan while he's panicked when he's in the jail, trying to figure out how somebody can help him bond out. And given the fact that I think for most of us, we don't have a cell phone in jail, you remember a few phone numbers at best, trying to figure out how you can get bonded out. He only talked to Ms. Ryan very briefly, less than a minute each time, and it was only about bond in hopes of trying to connect with his mother or somebody else who could assist in posting the bond. Yes, he did then, after getting bonded out, and so maybe let me finish that first part of the argument as I mentioned at the bench. I think phone calls from the jail before an individual is released on bond, on a conditional bond under 6.106D, terms of conditional release apply when an individual is released on bond.
Does it say that?
It says that the court may order the pretrial release of the defendant on the condition or combination of conditions that the court determines are appropriate. And it lists all the
Different than
conditions.
what you just said. You're trying to argue to the court that those conditions don't apply until such time as he leaves the jail.
I'm reading it under what the pretrial release terminology would seem to indicate, and it's my contention that it would indicate that the condition applies once the person is released on bond. When they're in jail, they're not on a bond. And so for the phone calls.
No, they're on a bond, they can't pose.
So therefore, they're not on a conditional release.
Really, you
Until
want
they
to go
can
into a
post.
semantical game with me.
I don't. I'm just trying to argue from
Okay.
the plain language of.
Then the plain language, then we can skip all of that because I think you're just plain wrong. But we can skip all of that because he's at the house.
Yes.
So what do you do then, Mr. Fikowski, with the language that read, do not go to the address in Whitmore Lake?
Your Honor, I concede he violated the condition of bond that required him not to go to the marital home. He did not have contact with Lindsay Ryan. My understanding is she was outside of the home. He had nowhere else to go. They have 5 kids. He went there while she was away to help do part of his parental responsibilities with the kids while he could when she was gone. He understands that technically violates that condition of bond.
Technically?
I only mean that in the sense that in context, Your Honor, it is his marital home and he was not having contact with Miss Ryan. And so I would ask
That
the
he's
court.
alleged to have committed a domestic violence. I understand his property right to the home, but not to his wife.
I understand, Your Honor. I would just ask the court to consider in the context of a situation like this, where he's the sole breadwinner, he is employed at Mount Brighton, he's a snowmaking manager, has been for 15 years. If he is in custody, he will lose that job and it's going to cause a lot of suffering beyond just my client here. A GPS tether, a stern reprimand reminding him that every single bond condition is obviously in order of this court. And I don't dispute that, Your Honor, but I would just ask that the court extend some recognition for the context of this situation.
I will adjourn this matter to December 30th, 2025, 9 a.m. At this time, because of the violation of defendant's bond is hereby ordered to revoke defendant's remand.
Your Honor, we did want to set for preliminary exam. I think all
All right,
discovery.
hold him for a second. Preliminaries, all discoveries complete?
Yes, Your Honor.
That preliminary examination, December 23rd, 2025, 12 noon, that's before me. Bond is still revoked. Defendant's remanded.
Thank you, Your Honor.
Court calls the case of the People versus Kirby Schneider.
Calls for the people in all three matters.
Good morning, Your Honor. Christina Costantino, appearing on behalf of Ms. Snyder in case number ending in 1426.
Stephanie Can on behalf of Ms. Snyder, who is standing to her right. Could you state your name for the record? Kirby Snyder.
All right, what are we doing on this?
Your Honor, as it relates to cases ending in 1489 and 0415, we are asking for a 2-week adjournment.
Your Honor, with regards to my case ending in 1426, this matter was previously set for a preliminary exam, and we would ask for it to be reset for a preliminary exam.
One 426 was previously set.
It was, Your Honor.
It was before Judge Moore. The defendant failed to appear on November 18th.
That's correct.
Severs, represented by Mr. Staten, and we have Mr. View from the prosecutor's office. We are here today for a pretrial. Mr. View, what's our status?
Your Honor, the state made a plea offer in the case just about a month ago to Ms. Severs of a plea to reduce count 1 to a 3rd-degree felony trafficking in fentanyl-related compound. We do a PSI as an open sentence. The state would leave the sentence to the court and dismiss counts 2 through 9. Today, Ms. Severs is formally declining the state's offer on the case, and we're setting it for trial.
Mr. Staten, what's our status?
Your Honor, I believe that is the same. I believe that is all accurate. My client would prefer a little more time. The discovery was voluminous. We had to track down some other work records and things to see what potential defenses were available to her. I've explained to her, and I talked to Mr. View about that. The state is not willing to continue their offer for another pretrial. And so at this point, she has decided to decline the offer.
I mean, the essence of the case is not going to change, right? I mean, we have all the discovery exchanged. It's just the decision that needs to be made, right?
It is, Your Honor. And I will tell the court that there's some custody issues and questions about how, a conviction would affect that regarding our minor child. It's not directly involved with this case, but that is what is causing her consternation at this point.
Okay, so the reason that I put these discussions on the record, Ms. Severs, is because this is a critical moment in the case. You're charged with a couple of different charges, but the 2 charges that are the most significant are the trafficking in drugs and the possession of drugs on the 2 separate days, because those carry with it mandatory prison sentences. That means if you are convicted of those, the court has no choice but to sentence you to at least 2 to 3 years in prison. When I say 2 to 3, 2 is the minimum with the possible indefinite sentence of 3 years. So I have no choice. If you are convicted of these offenses, you have to go to prison, and you have to go to prison for no less than 2 years. The offer from the state is for you to enter what is called an open plea to a 3rd-degree felony. That means that there is no mandatory prison in the case, and that I could sentence you to something less than that. Generally speaking, somebody with no criminal history who is not directly involved in the hand-to-hand sale of these, it's my understanding, based on our pretrial discussions, that you were mostly accused of just being the driver. If that is in fact the case, then I would probably not impose a prison sentence, and you would still be looking at probably some amount of local time based upon, when I say local jail time based upon what I know now. I know these are big and weighty issues, but at some point we have to decide how it is that we're going to move forward. We all have our roles in this process, Ms. Severs, and my role is to preside over the case. My role is not to determine what you are charged with or what plea offer is available to you. That is Mr. View's role in this process, and he is the one who controls whether he makes an offer or not, how long it stays open, and all of those sorts of issues. I don't have the ability to tell him, hey, you need to leave your offer open a little bit longer. Do you understand all of that?
Okay. I do though. I really feel like I need to tell him something. The thing that I'm concerned about, one, I've never been in trouble. This is new to me. So all of this is a lot. Two, it's my daughter that I'm worried about. They're stating if I get any type of time, whether it be jail, prison, it doesn't matter, any type of time other than probation, she's being taken away from me. That's what I'm worried about. So I just don't know what to do. I don't know what to do. I'm sorry.
Ms. Severs, I don't want to seem unsympathetic to your situation. I understand that this has significant consequences, but these are very serious charges. But it's also my understanding that, if I were to give you, let's say we were to set this for another pretrial, even in 2 weeks, the basic decision that you have to make, whether or not you are going to proceed to trial, it's not going to change. And you're not going to get any additional information about what's going to happen with your child or what's going to happen at trial or any of that. We're not going to push the ball forward in that regard. You're still going to have the same terrible decision in front of you, whether it's we make that decision today or we make it in 2 weeks or we make it in 10 weeks. It's not that the basics of it is not going to change, right?
Okay. I just wish I had more time. Oh no.
Well, let's do this. We got some other stuff that we have to take care of on the docket. Mr. View, you're around this morning, right?
I am open this morning, Judge, yes.
So why don't we do this? Mr. View, if you would be kind enough to extend your offer for an additional half hour. So we'll have a decision by 10:45, and we don't need to come back on the record to do that, Mr. Staten. You just let Ms. Kuroko know you don't have to stay around here, Mr. View. You can go back up to your office. We'll call you. We'll either set it for trial or we'll get some plea paperwork done and we'll go forward with the plea. That way we'll have some resolution today and we can all get back to the other things that we got going this morning.
I did print out the plea form, so I'll leave it here on the table if Mr. Staten needs it.
Thank you. Okay, and then just let Ms. Kuroko know. But if we haven't heard to the contrary, by 10:45, we're going forward on a couple of F2s. Understood? All right, that's all.
Thanks, Judge.
Thank you.
Okay. I have before me a plea form that indicates that the defendant would be pleading to count 2, a joyriding first offense, which is a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also the prosecutor will recommend that the defendant be sentenced as a first offender pursuant to the statute.
That's our full understanding, Your Honor.
That's correct, Your Honor.
All right, very good. Sir, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
State your name again for the record, please.
David Lyons Nose.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of joyriding. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand all of that, sir?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Did he do an advice right?
Your Honor, I did submit one to the court that he authorized me to sign with his permission.
Okay, you went through an advice of rights form with your attorney?
Yes.
Gave him permission to sign that?
Yes.
All right. Do you have any questions regarding any of those rights?
No, sir.
Under paragraph 5, you understand that those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form. You understand that, sir?
Yes, sir.
All right. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 1st, 2024, at the location of 2771 Plymouth Road, City of Ann Arbor, Washington County, State of Michigan. What did you do involving a vehicle belonging to Lansing Kita that makes you think that you're guilty?
I drove away without her permission.
All right. Everybody knows that. Sir, I do have to advise you that if I accept your plea, and if between the time of your plea and the time of your sentencing, you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the defense, Your Honor.
None from the people.
And have I complied with the court rule, and would it be proper to accept this defendant's?
People are satisfied, Your Honor.
And the defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 2nd at 8:30.
January 2nd, 2026, 8:30 before Judge Perry. Bond in this matter will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Daniel Cummings.
The children's attorney on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cummings, who is approaching.
Your name, sir?
Daniel Cummings, Judge, Your Honor.
Your Honor, I do have a green sheet. We are requesting an adjournment. We are going to refer Mr. Cummings to a Veterans Treatment Court. He does live out of county, so
Gonna take a minute.
Redford.
Would you be able to get that accomplished by the 30th, or you need more time than that?
Thank you. We can try. See where we can get.
Probable cause conference will be adjourned to December 30th, 2025, 9 a.m. Bond will continue.
Your Honor, Mr. Cummings would like me to address bond.
Briefly.
Your Honor, Mr. Cummings is requesting a personal bond. He is currently in custody with significant medical issues. As you can see, he wears a brace. He has to wear that 24 hours a day. He about a year ago received a back surgery that involves getting 14 rods in his back. He has to sleep in a certain type of bed, which obviously is not available here in the jail. He also has cystic fibrosis, so he has to wear a vest to shake his lungs. He cannot use that in the jail. He also uses a nebulizer, but he cannot use that in the jail. He's on about 18 different medications, and he cannot receive most of them while in
Shot every day
custody.
for my bone deterioration.
His osteoporosis, he says he receives a shot
Every day.
Every day, cannot receive that in the jail. So these things are accumulating. He is relying on one lung to breathe as one of his lungs is collapsed. So he's really struggling.
That doesn't account
medically.
for his fentanyl use, does it?
No, it doesn't, Your Honor, but.
I know, and that's the reason that you're in and why I revoked your bond.
Right.
We'll continue, Ms. Perry, briefly.
You know, I think Mr. Cummings, this is his first offense, his first time being on bond, his first time ever drug testing, doing anything like this. I think he's really learned potential consequences of his actions. He's been incredibly remorseful to me every time we've spoken, and I think he's incredibly willing to commit to any bond conditions the court may order. He's discussed testing every day and home confinement. He really wants to get home to his wife who has Alzheimer's. He's just really struggling.
May I say something, Judge? Please. I'd like to address, I want to say thank you for locking me up. It allowed me to get off of drugs, and I feel my mind is clear, my body's clear. I feel fine. I have no urge to, this kind of place is not for me. I've never been, don't have a criminal record. I've never been in jail.
On November 18th, when's the next time Judge Momore's here? Or if
Joking forward to next year.
I'll just. I need this to. On the 20th, no, then we'll put it before.
I'm not sure who's going to let you do these to treatment.
Next week.
I'm going to try to put you out to treatment.
In the case ending in 1426, we'll reset the preliminary examination in person for December 16th, 2025, 9 a.m. That is before Judge. Bond continue.
I'm sorry, Your Honor, what was the PCC date? 12/23?
Well, I haven't said
Oh,
that.
thank you.
That's that. And then that's on Ms. Constantino's case. On the other matter, I will set the probable cause conferences to December 23rd, 2025.
Try to get you out.
9 a.m. Bond continue.
That's it? Yeah.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Robert Bragg.
Good morning, Your Honor. Dan Guerin on behalf of Mr. Brabs. Can you state your name, Mr. Brabs? Robert Brabs. Your Honor, our substitution was just entered in. I'm asking for adjournment. If I could have a few weeks, I understand there's a mitigation letter that may need to be submitted.
You want something next year?
Yeah, I would.
Any objection from the people? Probable cause January 8th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case of the people versus William Riddle.
Alexander, on behalf of the people.
J. Grant Miller, P58658 on behalf of Mr. Riddle, who should approach from the back.
There's nobody at the door. I'll pass that one.
Thank you, Your
Court does call the case people versus John Bourdine. Oh, is that Riddle? Let
Riddle.
We're back on the Riddle case. Your name, sir?
William Michael Riddle.
All right, what are we doing?
Your Honor, I've spoken with the prosecution on this matter, and I'm not sure that I have all of the
Your Honor, I believe that this case has a related case that was previously dismissed. I think the discovery that was sent was related to that previous case rather than this case. So I need to get this case as well.
To count.
I was ready to set it for an exam, Your Honor, but maybe with the wrong info. So
Probable cause conference will be adjourned to the next available date. What's? I'll adjourn it out 1 week, get the discovery to them, then we can decide what we're going to do. December 18th.
Thank you, Your Honor.
2025, 9 a.m. bond condition.
Thank you, Your Honor.
Thank you. Court does call the case People versus John Bourdine.
Good morning, Rob Chico on behalf of Mr. Bourdine. He's approaching the podium.
Your name, sir?
John Bourdine.
All right, what are we doing?
Judge, I was just recently retained on this. His wife is a co-defendant. My understanding, the PD set their piece, they adjourned their PCs to the 30th. Can we have that date also?
That objection, probable cause conference, December 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court calls case the People versus Tamara Head.
Another Overwater Assistant Prosecuting Attorney for the People.
Christina Costantino appearing on behalf of Tamara Head. Ms. Head, can you unmute and state your name for the court?
Tamara Head.
Say your name again. You didn't come to my screen.
Tamara Head.
She not coming to my screen.
I can see her for what that's worth.
Go ahead. Say your name again, ma'am.
Tamara Head.
It is not. It's not pulling up on either of my machine. I will take her word for it. All right, what are we doing?
Judge, I believe discovery is complete, so we would be asking for an exam in this matter.
Discovery is complete.
To my knowledge, yes, Your Honor.
All right. People have their witnesses available the 23rd.
We can certainly try, Judge.
Preliminary examination in person will occur December 23rd, 2025, 9 a.m. Is that right? Before Judge Barr. Bond will continue. Thank you.
Thank you, Judge.
Court calls the case People versus Christopher Thaxton.
Kenneth Overwater Assistant Prosecuting Attorney for the People.
James Fifelsey on behalf of Mr. Thaxton, who is approaching. Can you please state your name for the judge?
Christopher Thaxton. Thank you.
Your Honor, there is extensive discovery. We're asking for an adjournment for all of that to come in and for time for Mr. Thaxton and I to review that.
You want the 23rd or 30th?
30th.
Probable cause conference without objection will be adjourned to December 30th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls the case People versus Matthew Burville.
Christina Costantino appearing on behalf of Matthew Verveil. Matthew, can you please unmute and state your name for the court? Matthew, I need you to push the unmute button. It's the microphone button in your bottom left corner, usually a red button. There you go.
I got it.
Please state your name for the court.
Matthew Verville.
All right, what are we doing?
Your Honor, I do believe discovery is complete to my knowledge, and I would be asking for an exam date, although I would ask if the court would consider giving us an exam date a little bit further out, given the volume of discovery I've recently received.
Objection to a January date.
Will the 6th work?
Yes, Judge, that will work.
Will people have their witnesses available that day? Preliminary examination in person, January 6, 2026, 9 a.m. That is before Judge Barr.
Thank you.
Thank you, Judge.
Bond continued. Thank you. Court calls the case People versus Christopher Brewer.
Good morning, Your Honor. Assistant Public Defender Davey Leba on behalf of Mr. Brewer. Mr. Brewer, could you please tell the court your name, sir?
Christopher Brewer.
And Your Honor, we're going to be requesting a adjournment in order to receive some media.
Probable cause conference will be adjourned December 23rd, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Court calls the case of the People versus Keith Walker.
Trevor Mabel.
Christina Costantino on behalf of Mr. Walker. Keith, can you please unmute and state your name for the record?
Keith Walker.
Better.
Your Honor, we have reached.
Next time he needs to get dressed, but go ahead.
I see that, Judge, and my apologies on his behalf. We have reached a misdemeanor resolution, but we do need to get the signed paperwork to the court. So I would be asking if the court would allow us a 1-week adjournment to facilitate that paperwork.
We'd be able to be dressed in 1 week?
I sure hope so.
Yes.
Probable cause conference will be adjourned to December 18th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thanks.
Thank you. Court calls case People versus Tory Brooks.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Brooks. Mr. Brooks, state your name for the record, please.
Tory Brooks.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant's going to be pleading guilty to count 2 of use of cocaine. That's the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement, and he understands that I'm not sentencing him.
Yes, that's correct.
All right, I will check that box. All right, that's the agreement, folks.
Yes, Your Honor. Yes, Your Honor.
All right, may I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Tory Brooks.
Sir, it is this court's understanding you're going to plead guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
Yes, I'm on probation.
All right. Were you on probation at the time of this offense?
Yes.
All right. I need you to understand that this could be considered a violation of your probation. Do you understand that, sir?
But actually, I wasn't on probation at the time.
You were not?
It was not, Your Honor.
You sure? Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
On the date of December 4th, 2023, at the location of Dawn Avenue near Panama Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time of your plea and the time of your sentencing, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence evaluation or recommendation the court would no longer be bound by. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be set for
January 8th at 10 a.m.
January 8th, 2026, 10 a.m. before Judge Washington.
Your Honor, I would like to address bond.
briefly.
So Mr. Brooks was remanded at his last court date for positive THC tests.
Correct.
Your Honor requested a copy of his medical marijuana card. He indicated his probation officer did turn that into the court. I also have a copy that is valid. It was issued in 2025 and expires in 2027.
Any response from the people? No way, he didn't have it before.
I think he lost the card but then his partner found it at home.
I'll grant the motion. His previous bond is reinstated.
Thank you, Judge.
You're welcome. Court does call the case of the people versus James Williams.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Christina Costantino appearing with and on behalf of Mr. Williams. James, can you please unmute and state your name for the record?
Oh, that was good. State your name, sir.
James Williams.
Thank you. Sir, I have before me a plea form. Is that what we're doing today, counsel?
Judge, we have reached a resolution, but there have been some additional issues that have came up since that documentation was submitted. Given that we would ask the court for a 1-week adjournment, so that way we can resolve those. We
Are
tried,
you
Judge.
available the 23rd? I'd rather not go 1 week if I can help it. But
The circumstances are somewhat time sensitive. I understand the court's reluctance. But
that what are time sensitive?
The circumstances that for which we need the adjournment.
Probable cause conference, December 18, 2025, 9 a.m. Bond continued.
Thank you,
Your Honor.
Judge. Court calls the case, People versus Jessica Hess.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Bellinger on behalf of Ms. Hess, who approaches. And Ms. Hess, can you please state your name for the record?
Hi, Jessica Hess here.
Thank you.
Your Honor, I have submitted a recovery court referral from Ms. Hess. I'm sorry. My understanding of the current offer is that there's a tentative offer for use with 7411. That's going to be conditioned upon completion of treatment. I am asking for bond in this case so that she may leave and submit herself to an inpatient facility. She was on
her own.
On her own. She was at Bear River, Your Honor. She does suffer from agoraphobia. She's willing to do home confinement GPS tether for the time being while she waits for an inpatient facility bed to open up. Like I said, a recovery court referral has been completed just in case. However, we are looking at a tentative offer here.
I will allow release to inpatient. I'm not going to just release her out.
Understood. I will submit that order by the end of the day, Your Honor.
Correct. What do you want me to do with this case?
I would ask for an adjournment for such time that she can get into an inpatient bed.
Well, let's see what happens. I'll adjourn it to December 30th, 2025, 9 a.m. so we can monitor it. Bond continue.
Okay, I will submit that order.
Thank you.
Thank you, Your Honor.
Court does call the case, People versus Antonio Young, 3 cases.
Christina Costantino appearing on behalf of Mr. Young in case number ending in 1177.
Stephanie Cannon appearing on the matters ending in 1381 and 5188.
I don't know about having you two on cases together, but that's all right.
Yes.
This is like the
Dynamic
second time.
duo.
Yeah, it's kind of scary. All right. Do you have a client?
I have reached out in just about all the formats that I have, Your Honor, and I have not had any contact with him. Hopefully, Ms. Costantino has.
Is he in Zoom?
I have had contact with him, Judge, and I've been in regular contact with him. He is on Zoom. I see him. So, Antonio, could you state your name for the court?
Antonio Young. Thank you.
Your Honor, since I have not had the opportunity to speak with him, I am asking that his 2 matters be adjourned so that I can communicate with him.
And
Ms. Constantino,
Judge, I would
What are
be
you
asking the
requesting?
same. I have been in contact with Mr. Young. He's been very responsive to me, so I'll make sure the public defender has accurate contact information for him. There was a global offer that was extended. We were working on negotiating parts of that global offer. So to continue those negotiations, we would ask for an adjournment of the PCC.
And Your Honor, I would concur. Offers have been made. I just have not been able to convey them.
Probable cause conference, I'll adjourn this one January 8th. He's out. 2026, 9 a.m. Bond continue.
Thank you, Judge.
Yeah. Court does call the case, People versus Thomas Johnson.
Alexander, on behalf of the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Johnson. State your name for the record, please.
Thomas Johnson. Thank you.
Your Honor, we're requesting an exam date.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd. Preliminary examination in person will be set December 23rd, 2025 at 12 noon. That's before me. Bond will continue. Thank you. Court calls the case People versus Haley Garcia.
Good morning. Oh, my apologies. Good morning, Your Honor, to you and your staff, Attorney Maxwell Dubin, P number 86012 on behalf of Ms. Garcia.
You here?
Oh, I am. Sorry. Haley Garcia.
Okay, there she is. Okay, thank you.
Yeah.
What are we doing?
Your Honor, today's the date and time set for PCC. I'm asking if we can get another adjournment on this. I am almost completely finished with the deviation letter. There are some potential immigration issues at play, so I've been working with the immigration attorney, Your Honor.
January 8th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Hope you and your staff have a great day and a good holiday if I don't see you.
You do the same, sir.
Thank
Court
you.
calls case People versus Adam Perala.
Trevor Maybell for the people.
All right, Your Honor. Good morning. Lori Daggy, Assistant Public Defender with and on behalf of Mr. Perala, who's the first name. Did you say your name for the court?
Adam David Perala.
Thank you.
And I apologize, Your Honor. I do have a green sheet.
Yes.
I'm requesting an adjournment for a couple of reasons.
Got it. Probable cause conference, December 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Tanisha Akins.
Sorry, Your Honor, which case?
Akins. Miss Apple is the one listed.
Assistant Public Defender Hannah Apple on behalf of Ms. Akins, who should be appearing via Zoom.
Miss Akins,
Tanisha Akins.
I need a camera, please. Thank you.
Tanisha Akins.
You're requesting an adjournment.
Yes, Judge. She's working on paying some restitution on the one file, and then the other case is, and this is the first PCC for that, so we asked for an adjournment.
January 8th, 2026, 9 a.m.
Thank you.
Court calls case People versus Cameron Curtis.
Good morning, our object on behalf of Mr. Curtis. Mr. Curtis, did you state your name?
Cameron Curtis.
Judge, I was just recently appointed, but I did receive all discovery. We're ready to go to exam, Judge. We would ask for an exam date.
So discovery is complete, you know.
Yes, Your Honor.
People have their witnesses available the 23rd.
We'll track that date, Your Honor.
Preliminary examination in person, December 23rd, 2025, 9 a.m. before Judge Barr.
Thank you, Judge.
Bond continued. Thank you. Court calls case of the People versus Hiba Al-Shabani.
Trevor Maybell for the people.
And Alex Warren Green on behalf of Miss Al-Shabani.
Your name?
Hi, Heba Al-Shabani.
Thank you.
Your Honor, I'm requesting an adjournment in this case to review discovery with my client and speak with the people. Get my text.
Probable cause conference, January 8th, 2026, 9 a.m. Bond conference.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Tyshawn Allen.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Allen. Mr. Allen, state your name for the record, please.
You have him. There he is, right there. Mr. Allen? State your name. He's frozen sideways. He's there, but he's frozen at this point, so.
Well, Your Honor, I have two requests. The first being an exam date.
I'm not gonna set an exam unless I can see him, and that's what he wants, so I'll pass it, you can try to get him.
Okay. Yeah, it looks like he's gone again. All right, thank you.
Yeah, I don't. Court does call the case, people versus Bonnie St. John.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. St. John. Ms. St. John, state your name for the record, please.
Bonnie St.
Your Honor, I'm requesting an adjournment so Ms. John and I can have some more conversations. An offer was made. I just want to make sure she fully understands that offer. And she would like to renew her bond motion. I know I made one at a previous probable cause conference. She is hoping to be released. If she were to be released, she'd go home to her husband in Canton. She is interested in doing treatment, and she did have that set up prior to being in custody. And she does have significant medical issues she wants to address.
There's nothing new from the last time.
No, Your Honor.
Set probable cause conference December 23rd, 2025, 9 a.m. Motion for bond reduction tonight, bond continue.
Thank you, Your Honor.
Court calls the case, people versus Malik or Malik. Acedo, Acedi. What'd you say?
You said you did great.
I said you got it. Trevor Mayville for the people.
And Stephanie Cannon.
Always good. Thank you for saying that. The attorney has never said that.
You're amazing, Your Honor.
What do you want?
Your Honor, we're asking for a 2-week adjournment. Mitigation information has been prepared. We just have to get it over to the prosecutor's office.
He's out, so. We'll adjourn this matter to January 8th, 2026, 9 a.m. bond.
Thank you.
Thank you, sir. Court calls the case of the people versus Randolph Taylor.
Trevor Mayville for the people.
Assistant Public Defender Chelsea Virgil with and on behalf of Randolph Taylor, who approaches. Mr. Taylor, please state your name.
Randolph Taylor.
Thank you.
Your Honor, we're asking to set a preliminary exam, and I would ask to address bond.
Or would a Thursday be if you did? So discovery is complete.
Yes, Your Honor.
And would the people have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person will be set December 23rd, 2025. 12 noon, that's before me. Yes, Esteban.
Your Honor, Mr. Taylor has been in custody for a couple months now. He has this uttering and publishing case, and then one other case, Judge Froschauer, that's a retail fraud 3rd degree.
Is he released on that case?
He's not. It's a low cash bond, but he has court on Monday, so I'd be asking Judge Froschauer for a personal bond on Monday. I'm hoping we can resolve that case on Monday. Mr. Taylor would be staying in Ann Arbor. He has no convictions in the past 5 years, and he continues to see currently as he did before he was in custody.
Any response from the people?
Your Honor, based off the nature of the case, I'm not proposing release.
Defendant's bond is reduced $5,000 personal recognizance fund.
Thank you, Your Honor.
Thank you. Conditions remain in effect. Court calls case People versus Renee Andrews.
Andrew Childers appearing on behalf of people. Morning again, Assistant Public Defender Davi Lebo on behalf of Ms. Andrews, who stands to my right. Ms. Andrews, will you please tell the court your name?
Renee Andrews.
And Your Honor, we're going to be requesting adjournment today in order to receive some media, please.
I'm sorry?
We're going to be requesting adjournment today in order to receive some media, please.
Probable cause conference will be adjourned January 8th, 2025, 9 a.m. bond, or 26, 9 a.m. bond continues.
Your Honor, was that the 26th?
The 8th.
The 8th, thank you.
9 a.m.
Thank you.
Thank you. Court calls case People versus Patrick Williams.
Alexander on behalf of the people.
Mr. Williams, Assistant Public Defender, Tanaka Carey, I can really, Your Honor, on behalf of Mr. Patrick Williams. State your name for the record, please.
Patrick Michael Williams.
All right, thank you.
Judge, we'd like to set this matter for exam, please.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 23rd. Preliminary examination in person, December 23rd, 2025 at, or 9 a.m. before Judge Barr.
Thank you, Judge.
Continue. Court calls case People versus Santana Arrington.
Stepping in for Ms. Your Honor, Trevor Mabo for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Santana Arrington, who should appear via Zoom.
Yes, I am here.
State your name.
Santana Arrington.
What are we doing?
Your Honor, this case is being dismissed outright by the people.
And I have no objection.
Case is dismissed. Now I press. Thank you.
Thank you.
Court calls the case People versus Tanaris Williams.
Or yeah, the Assistant Public Defender with and on behalf of Mr. Williams, who's approaching. Could you say your name for the clerk?
Tanaris Williams.
And Your Honor, we are requesting adjournment.
Probable cause conference, December 23rd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus Rick Artuso.
Middleton Water Assistant Prosecuting Attorney for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Artuso, who should be appearing via Zoom. Mr. Artuso, can you please state your name for the record?
Rick Artuso.
And Your Honor, I am requesting to adjourn this matter. We are looking to see whether a resolution is possible.
He's out at this point.
That's correct.
Probable cause conference, January 8th, 2026, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor.
Court calls case People versus Melinda Baker.
Middleton Water Assistant Prosecuting Attorney for the people.
Defender Tanaka Carey, I can really, Your Honor, on behalf of Ms. Baker, who should be present via Zoom. Ms.
I'm
Baker?
here. I'm
What's your
present.
name?
Melinda Baker.
All right, go ahead.
Your Honor, we're requesting an adjournment in this matter. We're working on mitigation to submit to the people.
Public cause conference, January 8th, 2025, 2026, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you.
Court calls case People versus Samuel Allen Dabney.
Honor, I think for the Assistant Public Defender with after Mr. Dabney. I apologize. I do have a green sheet filled out, but our office indicated that retained counsel would be here, so I'm requesting an adjournment. Oh, thank you.
Who was he?
Thank you. Thank you, defendant. I'm sorry, Your Honor.
All right.
Great, Judge.
Yes, sir. Your name, sir.
Kerry Mitchell is appearing on behalf of Mr. Samuel Dabney. My P number is 42028. We just respectfully like to get a exam date. I have received the discovery.
Thank you. People have their witnesses available the 23rd? No? You know. 30th work for you, counsel?
I'm sorry?
The 30th?
The 30th?
Yeah, I can do the 23rd, but counsel won't be here.
I'm going to be on vacation on the 30th. I mean, I'm sorry. I'm not going to be in town.
So now I want to ask where he's going.
Yeah. I started to say it out.
Yeah, I know you did. Everybody was like,
the 20, what is the date like?
I do need what day?
I can do it the 23rd.
You won't be here on the 23rd.
But your partner will be?
No. She has no partner. She is a woman unto herself. No. I don't. I'll set it for whatever date you guys.
I would prefer earlier dates than later, though.
Okay.
If it's set for the 23rd, I could try to make it work, but we have several people are going to be out of the office.
Yeah, it's
for Christmas.
I mean, well, today's what? I can try for
Judge, let's do the 30th. I'll adjust that because I don't want to move this. I want to get this.
Right, I got you. Okay.
Let's do the 30th.
Preliminary examination in person, December 30th, 2025, 9 a.m.
I would respectfully ask though, the people, if some officer or something that's not going to be available, to please contact me prior to that date so that I can still leave on a day, you know. You know what I mean?
I'll set it 12. It's set at 12 noon before me.
Okay.
Bond continued.
All right. Thank you, Judge.
Thank you, sir.
Have a great day.
Court does call the case People versus Deja. Looks like Banbury.
Stephanie Cannon on behalf of Mrs. Banbury.
Good morning, Your Honor.
Please state your name.
Deja Monique Banbury.
And Your Honor, I am asking for an adjournment in this matter. in order to have meaningful conversations with my client regarding this particular case. Her actual attorney was in an accident this morning.
Probable cause conference, January 8th, 2026, 9 a.m. On continue.
Thank you.
Thank you. Court calls case People versus Manuel Arnthouse.
Bob Dallas here, prosecuting attorney on behalf of People.
Stephanie Cannon, on behalf of Ms. Barkhouse, who's appearing via Zoom. Could you please state your name for the record?
Manuel Barnhouse.
And Your Honor, I'm going to ask for an adjournment. Some information has come to my attention. I do definitely need to speak with my client regarding that information. I'm asking for a 2-week adjournment.
We'll also adjourn this one. Probable cause January 8th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Thank you.
Court calls case People versus Derek McGuire.
Trevor Maybell for the People.
Assistant Public Defender Jay Bellinger on behalf of Mr. McGuire, who approaches, Your Honor. And Your Honor, if I don't know if you'll let us approach briefly on this.
Pardon?
I don't know if you'll let us approach briefly on.
Yes, you may.
Thank you.
Yes, in this matter, having reviewed the competency report, the court would find that the defendant is incompetent to stand trial and not restorable. And the people are attempting to try to figure out exactly what they're going to do.
That's correct, Your Honor.
So how long will it take for the people to figure that out? Because otherwise this thing is going to sit in limbo.
Your Honor, under normal circumstances, I would think 7 to 10 days would be plenty of time for me.
All right, then what I'll do is I'll make that finding, but I will adjourn for continued competency hearing. I guess it would be to the 30th, 2025, 9 a.m.
Thank you very much, Your Honor.
All right, thank you.
Thank you.
All right. We'll see you in a week, okay?
They have to get down and go.
Yep.
Got it. Court does call the case People versus Jessica Brascala.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Brascala. Your Honor,
Ma'am, can you state your name, please?
Jessica Brascala.
Okay.
Your Honor, we're requesting adjournment. There's some additional media that I would like and some other issues we need to work out.
Probable cause conference in this matter will be adjourned January 8th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you.
Be in touch, Ms. Brascala.
Yeah,
Court
but
calls case People versus Nathan Burgess.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Dottie Leba on behalf of Mr. Burgess, who stands to my right. Mr. Burgess, can you tell the court your name, sir?
Nathan Burgess.
And I'm going to be requesting an adjournment. We do have a resolution in this case, just need to get the paperwork together.
Public cause conference, December 30th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Court calls case People versus Garrett Carlton.
Assistant Public Defender Jay Bellinger on behalf of Mr. Calton, who approaches. Mr. Calton, can you please state your name for the record?
Garrett Carlton, good morning, Your Honor.
Good morning.
And Your Honor, we are just seeking to set this for preliminary examination. Discovery is complete to the best of my knowledge.
People have the witnesses available the 23rd.
Okay, I'll make a note in the file in my office. You can touch someone else who
Preliminary examination in person will be set December 23rd, 2025, 9 a.m. before
2 days before Christmas.
Judge Bar.
Okay.
Bond continue.
Let's take it.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case People versus Amaya Campbell.
People. That's one of Ms. White's cases. Assistant Public Defender Jay Bellinger on behalf of Ms. Campbell.
Ms. Campbell, can you state your name?
Amaya Campbell.
And Your Honor, my understanding is that we're just asking to adjourn to obtain video discovery in this matter.
Video.
Correct.
All right. This matter, probable cause conference will be adjourned January 8th, 2025, 9 a.m. or 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case People versus Dylan Chapman.
Then on behalf of people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Chapman, who approaches. Mr. Chapman, can you please state your name for the record?
Dylan Chapman.
And Your Honor, we are just seeking to set this matter for preliminary examination. To the best of my knowledge, discovery is complete.
People have their witnesses available the 23rd.
2 days before Christmas at 9 a.m.
Preliminary examination in person, December 23rd, 2025. That's noon. That's noon, and that's before me.
12 p.m. before Judge Simpson. We'll give you a call, okay?
Bond continues.
Thank you, Your Honor.
Court does call the case People versus Brian Coleman.
For the people.
Assistant Public Defender Nina Apple, on behalf of Coleman. Should be appearing via Zoom. Mr. Coleman, can you unmute and state your name for the record? And Your Honor, I know, I'm sorry.
Brian Coleman.
Thank you. I did previously submit a green sheet. However, Mr. Coleman does wish to waive his right to preliminary examination today.
Is that correct, Mr. Coleman?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count.
Your Honor, we acknowledge receipt of the information waived formal reading. My client will stay mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
February 2nd at 1:30 with Judge McNally.
February 2nd, 2026, 1:30 before Judge Hamoud. Bond continued.
Thank you.
Thank you. Court does call the case of the People versus make sure I pronounce it correctly. It's Zakara, is it Daphne Bersiaga?
Daphne Bersiaga.
Did what I could.
Please state your name for the record.
Zakara Daphne Bersiaga.
And Your Honor, I'm an Assistant Public Defender Jay Bellinger on behalf of Mr. Daphne Bersiaga, Your Honor, and we are just seeking an adjournment, is my understanding, for purposes of further negotiation.
Probable cause conference, January 8th, 2025, 9 a.m. Bond continue.
Thank you.
We'll be in touch, okay?
Court calls the case People versus Vasquez Davis.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
It's Zach and Ruley's case.
Sorry, Judge. Assistant Public Defender Chinazi Kyriakin-Ruli on behalf of Mr. Vasquez Davis, who's approaching. Vasquez, state your full name for the record.
My name is Vasquez Faison Davis.
Thank you.
Judge, we're asking for an adjournment in this matter. We are in negotiations with the people. There's also some media that we're looking to see if the people have, but if the court could give us the date for the 30th, that would be
Probable cause conference, December 30th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you.
Thank you.
Court calls case People versus David DeLucia.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Stephanie Cannon on behalf of Mr. DeLuca, who is approaching.
Your name, sir.
David Mark DeLucia.
And DeLuca. I said it, I was so close. And Your Honor, we're gonna, again, another case where we're gonna ask for an adjournment so that,
Ms. White.
yes, can meet with him.
Probable cause conference will be adjourned January 8th, 2026. And bond continued.
Thank you.
Thank you, sir.
What you need.
They're back up. Court does call the case People versus Kenyatta Dickerson.
Assistant Public Defender, Jay Bellinger on behalf of Mr. Dickerson, who appears via Zoom, Your Honor.
Mr. Dickerson, state your name, please.
Yeah, Jay Dickerson, Your Honor.
All right.
And Your Honor, we are just asking to set this matter for preliminary examination to my knowledge discovery is complete.
Preliminary examination in person will be set December 23rd. Will the people have their witnesses available?
We'll try.
2025, 9 a.m. before Judge Bar.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Court does call the case People versus Noah Bowen.
And then now we have people.
Morning, Your Honor. May it please the son of the court, David Burgess, on behalf of Noah Bowen, standing in for the attorney of record, Wade Fink, with Mr. Bowen's permission. Is that correct, sir?
Yes,
And then state your name for the record.
Noah Bauer.
Okay.
Bowen, thank you. And Your Honor, we're, discovery is complete. We're requesting, or Mr. Fink is specifically requesting exam in this matter.
People have their witnesses available the 23rd.
Can we go a little further out?
Mr. Fink's fine with that, Your Honor.
All right. 30th, or you need further out than that?
Can we do this?
Any objection?
That's fine, Your Honor. Actually, I think that's the date Mr. Fink preferred, so.
All right. Preliminary examination in person, January 6th, 2026, 9 a.m. That is before Judge Perry.
Sure.
Bond continued.
Thank you, Mark.
Thank you. Court calls the case People versus Tegan Donald.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender W. Lee on behalf of Ms. Dunham.
She here?
Your Honor, I have not spoken to her today. I did speak to her
Why
yesterday.
are you looking at the door? Where is she? Donnell?
I can't seem to find her, Your Honor. I'd ask the court would give me an opportunity to pass the matter to give her a phone call.
Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Jawante McFarland.
Andrew Phillips, attorney on behalf of the people.
At the door. They are not. Court calls case People versus Zachary Doran.
That's with people.
And Alex Warren, Green on behalf of Mr. Doran. Could you state your name?
Zach Doran. Thank you.
Your Honor, we are asking the court to set this matter for a preliminary exam.
And no objection, of course, Your Honor. We will let the court know that the victim is present in court and wishes to address the court again about the no contact order. I'm sure the court recalls the victim in this case is the defendant's father.
Yes.
Yeah, it's been 6 weeks. They're lying.
And I think I denied the no contact at that time. Is that correct?
You did, Your Honor.
All right. I'm not, unless there's something else, I'm not likely to change my mind. I'll hear from him, but
I need these files.
I'll set preliminary examination in this matter in person. December 23rd, 2025 at 12 noon. That's before me. Sir, I am not, just so that you know, I'll hear from you, but I'm not likely to address any issue regarding that. I'll hear it on the 23rd in any event. All right. Thank you.
And Your Honor, I think Mr. Doran specifically wanted to ask the court to reconsider the GPS tether. We weren't planning on addressing the no contact issue today, but when the people let me know that, I told my client that the complainant did wish to ask for contact. I know Mr. Doran's concern is he's asking the court to reconsider the GPS tether prevention.
At this point, I'm not going to do anything. I'll hear the exam on the 23rd and then I'll make a decision.
Thank you.
Understood, Your Honor. Thank you.
Court calls the case of the people versus Eric LZ Williams.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
The public defender, Hannah Apple, appearing on behalf of Mr. LZ Williams, from Ms. White. Your Honor, we are asking for an I'm sorry, will you state your name for the record?
Eric LZ Williams.
Thank you. There has been an offer extended, a misdemeanor offer. I'd ask for an adjournment to have that discussion with Mr. LZ Williams.
December 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Terrence Ginyard.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard, who approaches, Your Honor. Can you please state your name for the record?
How you doing today, Your Honor? My name is Terrence Ginyard.
Thank you.
And Your Honor, to address the matter first, we would just be asking for an adjournment. I did email Mr. Overwater. I'm looking into a reduction request, so I'd be requesting a couple of weeks on that.
Probable cause conference without objection, January 8th, 2026, 9 a.m. Bond continue. Thank you.
And Your Honor, without trying to push my luck here, I did just want to briefly address a condition of Mr. Ginyard's bond. With regards to the home confinement that he's currently on, he is asking for you to allow him a GPS tether in lieu of that for purposes of seeking housing, as he has to be out of his home by the end of February due to Section 8 no longer being available. Alternatively, he is seeking some time out on home confinement for purposes of doing the same.
And if I may say something, Your Honor, if you don't mind, so we slowed down at U of M for the season. I'm at another job at Aubrey's in Dexter. My agent knows all this, so he gives me the time out for that as well. I have to move from my place, not because of eviction, but because they're no longer taking Section 8. I talked to my housing choice voucher recipients, and they told me that Washtenaw County housing is like 4 months out the way. No one has places here, so I might have to move to Wayne, other places. They gave me a list and choice of places because I've been in my home for 5 years. But just calling around is not going to let me get into a place, and I'm trying to find just somewhere because I am a convicted felon. So I can't just go to like McKinley out here. Yes, sir.
Do people have a position on this?
Well, I also believe that today the matter is set for sentencing on a bond violation. So that would certainly be something of a concern. But the people see no benefit in Mr. Ginyard becoming homeless. So I would leave it in the court's discretion.
Your other probation has given you certain times out.
So I'm not on probation, Your Honor. I'm talking about as far as the ankle monitor that they had requested. The agent across the street has given me time to go see my daughter, who was in UNIC. That's now getting better.
I got you.
Yeah,
that's good to hear.
Yes, sir.
And what is he asking for specifically?
Your Honor, he is asking for a GPS tether in lieu of home confinement.
Just tracking.
Just tracking.
January 8th. Okay.
Good order.
At 9 o'clock.
9 a.m.
Okay.
All right, I'll switch this up to GPS tracking
Thank you very much, Your Honor.
on this matter.
Okay. Could that be broken down?
Bond violation.
You're no longer on homecoming. Packing is retracting.
Did you spend any time in? That's right, you mentioned the bond violation. You never spent any time in custody, is that correct?
No, sir. I was in jail and then I came out on bond conditions. I think it was
Since like holidays, you haven't spent any time in.
No, sir.
Anything you want to say before I sentence him on the violation? Well, you know what I'm going to do? I'm going to adjourn his sentencing on the violation to the 8th.
Okay.
of January. Thank you.
Okay. Yes. Okay. Thank you, Your Honor.
Court does call the case, People versus Devontae Garland. Devontae.
Good morning, Robert J. Kill on behalf of Devontae McFarland. Would you state your name for record?
DeJounte Durango McFarland.
Judge, may we approach very briefly?
You may.
Thanks. If you're voluntarily waiving, okay?
Okay.
Judge, today's the time for a PCC matter. My client has a history, as you know. I believe he's stabilized enough to know that he wants to waive the PCC and go up to circuit court. He has another matter with Judge Kunke. He's been working with Leah Deball, a therapist, and he's done really well with her in their 10 sessions she's had with him, and I hope to continue that with him. So at this point, we're asking to waive up to circuit court, and he signed the waiver form.
You understand all that, sir?
Yes, sir.
All right. And you understand that the preliminary examination, which is a hearing, you won't have that. You're going to go up to circuit court to resolve the matter.
Yes, sir.
All right. That's what you want to do?
Yes, sir.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. Mr. Killaway.
Thank you, sir.
Judge, we acknowledge and receive the information, waive its reading. My client will stand mute.
Defendant has to waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for. What are you doing?
I thought it was Judge Kunke, but maybe.
I have it as Judge Slay.
Okay, that's fine.
Pretrial will be set for January 8th, 1:30.
I'm sorry, what time?
January 8th, 26, 1:30 before Judge Slay.
You're right. It was my mistake. Sorry, Judge. About the
Bond
judge.
continue. Thank you. Thank you, sir. Good luck. Court calls the case of the People versus Michael Uchenauer.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Gokenhour should be appearing via Zoom.
Yes. There he is, trying to get unmuted.
Oh, hello.
Hello, state your name.
Michael Gokenhour, sir.
Okay. I have a plea form. Is that what we're doing?
Yes, Judge.
Sir, it is this court's understanding, the plea form at least indicates that the defendant is going to be pleading guilty to the charge of retail fraud second degree. That's a misdemeanor punishable by up to 1 year incarceration. Upon his successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. That is correct.
Correct. Okay. Sir, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again, please, sir.
Michael Gokenhour.
All right, now you can put the baby back in your arm. All right, you're welcome.
Don't
That's
forget the dog, the puppy.
All right, boy, a dog and everybody's here now.
Yeah,
All right,
we've got.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud, second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form or had your attorney sign one on your behalf after going through it?
Yes.
Do you have any question regarding any of those rights?
I do not, Your Honor.
Under paragraph 5, those are your trial rights. You understand that you're giving up those rights as well as all the rights that are contained on that form?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
And because you believe that you're indeed guilty of this offense?
I am, sir. Your Honor.
September 8, 2025, at the location of 3300 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Home Depot that makes you think that you're guilty?
I tried to walk out with items that were not mine. That I did not.
All right. The store was open to the public at the time?
It was.
You didn't have anybody's permission to take that property, did you?
I did not.
And was the aggregate value of everything that you tried to remove from the store, was that in excess of $200?
Yes, it was.
All right. Sir, if I accept.
Nobody ever gave me an exact amount, but I believe so.
Pardon?
Nobody ever gave me an exact amount, but I believe it was over 200.
All right, you're not disputing that it's over 200, is that correct?
No, I'm not.
All right. Sir, I have to advise you that if between the time of my accepting your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
I do.
All right. Are the people or the counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14-1 probation. Sentencing in this matter will be
January 14th at 9 a.m.
January 14th, 2026, 9 a.m. That is before me. Bond will continue.
Thank you, Judge. Mr. Gokenhour, call the probation department at the number I sent you yesterday, okay?
Okay.
Thank you.
Thank you.
Thank you.
Court does call the case of the people versus Brandon Myers.
North Overwater Assistant Prosecuting Attorney for the People.
Stephanie Canna on behalf of Mr. Myers. Mr. Myers, could you please state your name for the record?
Brandon Myers. Thank you. What are we doing?
Your Honor, for today's, we are asking for a brief adjournment of this matter. Additional information has come to my attention from the prosecutor. So we're going to adjourn this to see if maybe we can come up with a global resolution. And when appropriate, I'd ask to address bond.
This matters are adjourned January 23rd, 2025, 9 a.m. Yes, that's,
January 23rd, Your Honor?
I mean, December 23rd.
Thank you, Your Honor. Your Honor, as to bond, my client is asking if the court would be amicable to allowing him out on tether to his mother's house. My client is now receiving his mental health medicines, which was correlating to a lot of the allegations in this case. He is a helper for his mom. She's older. He does everything around the house that she needs to have done. He as far as the allegations goes, I explained some things to him that he didn't understand or realize. He does now. He has no intention on communicating with complaining witness in this case. And so he is asking for to be tethered to his house.
Your response from the people.
The people would object. In addition to the stalking allegation that he's facing, I just authorized new charges against Mr. Myers for operating while impaired. Second offense, and aggravated indecent exposure that occurred in August of this year. That time, Mr. Myers had methamphetamine, benzos, and cocaine and THC in his system, and he was arrested, passed out with his pants off, watching pornography with the windows down out in front of a restaurant where people were eating outside.
Motion to modify bonds denied. Bond will continue in both cases. Thank you.
Thank you, Your Honor.
Court calls case People versus Aaron Grable.
Kenneth Overwater,
Assistant Public Defender.
Attorney for the people.
Assistant Public Defender Jay Ballinger on behalf of Mr. Grable, who appears via Zoom.
Mr. Grable, can you state your name, please?
Aaron Grable.
Thank you.
And Your Honor, we are asking for an adjournment. My understanding is that the OIC is doing a little bit further investigation on this. We should hopefully wrap this up in the next couple of weeks.
Adjourned matter, January 8th, 2026, 9 a.m. Bond continued.
Thank you very much.
Court calls case of the People versus Derek Stewart.
That's calls for people. Apple.
Now. Mr. Stewart, will you state your name for the court?
Mr. Derek Stewart.
Thank you. Your Honor, today's the date and time set for a competency review hearing. Mr. Stewart, the court, I did receive yesterday, I believe it was sent to court as well, that they were able to do a review last week. That review still found that Mr. Stewart was incompetent, but is restorable. He is awaiting a bed at this time. I did wish to address bond when appropriate for Mr. Stewart.
All right. I will make a finding and I need an order that the defendant is still competent, or is still incompetent to stand trial, likely to obtain competence if provided a course of treatment. I'll set the competency review here and give me 60 out. Probably won't have it then, but February 12th, 2026, 9 a.m. Esteban.
Your Honor, Esteban, I know previously addressed bond for Mr. Stewart. We were working on getting some information to provide to the court more details. I will say following the last hearing, it was forwarded to me by Ms. Feltis that she received a letter from the Department of Health and Human Services that Mr. Stewart failed to appear for a 90-day review hearing. He had promptly notified, I believe Ms. Feltis actually sent the first email that Mr. Stewart was in custody, where he has been for the last 196 days. I am grateful that they were able to get him in earlier because originally they had him set for January 20th for the next review, but it appears they were able to get that done. However, I am asking if the court would consider a release, potentially even on a tether for Mr. Stewart. He's been in 196 days. I believe the delay from the CFP is of no fault of Mr. Stewart's. He receives Social Security disability, so he does have income. He reports that he has a phone in his property if he were to be released on tether, and he reports to stay at the Delana Center. Based on that information, I'd ask the court to consider a release on bond.
Your Honor, Ms. Apple and I did discuss this via email, and I indicated to her that because of the information I have from the Center for Forensic Psychiatry, that they do prioritize those over who are detained over those who are out on bond. I wasn't willing to agree to release. As the court knows, we do have a limited amount of time in which we can try to restore him. And so I was not willing to agree to any change in bond because I do think it will delay his submission to the Center for Forensic Psychiatry and will delay his restoration to competency and further delay his case.
I did receive that information as well from Ms. Feltus. However, I at this point, because of the delay being not of Mr. Stewart's fault, and I know that there's obviously great delay in waiting for a hospital bed for his treatment. He is
At this time, I'm going to deny the request. However, I will reconsider it at a later date if the conditions still remain the same.
okay.
Thank you.
Thank you, Your Honor.
Continue. Everybody else is in. Oh, court does call the case People versus Thamar Johnson. He's in too. Oh, there he is.
Stephanie Cannon on behalf of Mr. Johnson, who is appearing by Zoom. Mr. Johnson, when you are unmuted, could you please state your name for the record?
My name is Thamar Johnson.
Thank you.
Your Honor, I was able to meet with my client yesterday for quite some time to go over the case. We are missing discovery in one of the matters. Actually, I think we're missing bits of discovery in both matters. And I would like the opportunity to try and negotiate this information. So I would just ask for an adjournment.
I'll adjourn the matter December 30th, 2025, 9 a.m. Bond continue. Thank you. Court calls the case People versus Jeffrey Williams.
Andrew Childers appearing on behalf of Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williams, who's approaching now. Mr. Williams, will you state your name for the record?
Jeffrey Williams.
Thank you.
He's waiving.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
All right. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having the way defendant bound over to circuit court on a single count.
Thank you, Your Honor. We acknowledge receipt of the information. My client will waive reading. My client will stay mute.
Defendant and waive for a reading, standing mute. Court will not guilty plea. Pre-trial in this matter will be set for
January 7th at 1:30 with Judge Conlon.
January 7th, 2026, 1:30, Judge Conlon.
Yeah, that's what the bar.
Your Honor, Mr. Williams is wondering if he has a current order for release to treatment. I wasn't 100% certain. I know that he has.
Thought last time,
I should have one.
I thought that he had one here. And
I thought last time and I am familiar with Mr. Williams, there should be one for that. I don't see one. Not in this.
Okay, I will follow up. He has matters in circuit court as well that we're working on resolving with treatment options.
So that we're clear and knowing Mr. Williams, I'm not going to have any issue with signing an order for release to inpatient treatment.
Okay.
All right.
I will check that.
Okay.
Yeah.
Continue. Court does call the case People versus Bernard Brock.
Trevor Maybell for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brock, who's personnel. State your name for the record.
Bernard Eugene Brock.
Thank you. Your Honor, we'd ask for an adjournment of the probable cause conference today for negotiations and a review discovery. Client.
Probable cause conference, January 8th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
We'll be in touch. All right.
Calls case People versus Jalen Seal.
Trevor Maybell for the people.
Madam Carrie, I can review, Your Honor, on behalf of Mr. Jalen, who's approaching. Jalen, state your name for the record.
Jalen too.
Judge, we're asking for an adjournment in this matter. We're in negotiations with the people, but there's also some outstanding media that we need. looking to see if we can get surveillance footage.
How much time are you gonna need to get that done, given the nature?
Do 3 weeks, Judge?
January 8th, 2026, 9 a.m. bond.
January 8th. Thank you, Judge.
Court calls the case, People versus Robert Watkins.
Alex Warren Green on behalf of Mr. Watkins.
The facility did not sign in this case. I see you worked it out, but Jackson County, I think is where he was, is not signed in.
Your Honor, I'm completing a green sheet right now. I talked to Ms. Feltes, and I would ask the court to adjourn this matter so we.
All right, I will adjourn it. Do you know how long he's going to be in Jackson?
I do not, Your Honor.
All right. I'll adjourn it to December 30th. Let's see what happens. 2025, 9 a.m.
Thank you.
Court calls the case of the People versus Rayshawn Dawson.
James Wifelsky on behalf of Mr. Dawson, who was here earlier this morning, Your Honor. I've checked in the hallway, I've tried to call, emailed, cannot find him. I do not know how to explain his absence currently. Just asked for, maybe the court could issue a show cause here.
Yeah, it's gonna happen. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. Warrant will issue immediately.
Thank you.
Court calls case People versus Tyshawn Allen. Recall.
Andrew Jordan, attorney on behalf of the people.
Tyshawn Allen.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Allen. Mr. Allen, say your name for the record again, sorry.
Hi, Sean Allen. Gotcha. Okay, and I did see him. There we go. All right.
So, Your Honor, as I was saying the first time, and thanks for recalling the case, I have 2 requests. The first is a preliminary examination date.
Okay. People have their witnesses available by the 23rd. December 23rd, 2025 at 9 a.m. before Judge Bar.
My second request is a lifting of the no go-to provision. Mr. Allen's landlord has provided me documentation that the complainant has moved out of the apartment.
Do I have that?
I have.
Have the people seen that?
Your Honor, the Ms. Attorney did email to me 2 days ago. I have reviewed that. We've made efforts to either confirm or deny that information with the victim, and we have not been successful. So we haven't been able to make contact.
Let me see the line.
I do know the people tried to make contact with her before the last probable cause conference as well, and I don't think they were able to reach her at that time too. Mr. Allen just really wants to return home, as the court can imagine.
Okay, I get that. This is not signed.
Like a wet signature?
A signature. I mean, it's not signed. And so I would need something that's signed indicating that's the case.
I can work on getting that to the people in the court.
All right.
Probation for another 6 months. We will come back at the end of the year because he has a promotion waiting on him that will significantly change the financial situation for him and his young family. We did everything we were supposed to do. We paid everything. He has been an angel. They randomly UA'd him just a few weeks ago, just to be sure when we came here to court, nothing had come up. Nothing has come up. He has done everything he has been asked to do. For the probation department to show up again today, after they told him at the 3-year mark that they would agree to it, and then said no, that they would change it. And now they wanted 4 years. And now that we've completed 4 years, just goes to show you how I don't understand how we keep going back and forth, back and forth, back and forth.
I think it has everything to do with victims' rights.
Well, Judge,
which is
every case, like this is, but this is an accident.
No, but and you can say it, but it's still, legislature made it a crime.
Well, I don't understand why the court said that we were going to keep him on probation for another 6 months and see how this went, if that, and so here we are.
I really hadn't, until just now, I would think all family members of deceased who have lost their loved one forever can't help but think about that every day. Something we don't carry a burden over unless we've got a similar circumstance. But it's called accident, but it is made a felony crime by the legislature. It's a crime, which it's a felony offense. So it is. Let me complete. We've got the dynamics between these actions, which cost the life of their loved one, and I think it was whatever punishment. I think the agreement was whatever punishment shall not exceed a cap of 7 years in prison. What? That's what this
was a cap agreement here.
Oh, okay. So prison was an option. Probation was an option under the agreement, under the agreements. And I understand. I weighed those. And how long were you in custody?
About a few years.
And in a 7-year sentence, a third of that is about now.
five.
Yeah, I got 5. So, but a third of that is 1 2/3. Anyway, so he served longer than what would be a third. You said 2 years?
About a little less. Yes, sir.
Well, what the family wants is something really at the end of the day the court can't give, and that is the life of their loved one back. How do you do that? You can't. And it's and the worst part is accidents are accidents, but leaving the scene of the accident and not rendering help to someone who's left there to perish is just not humane. I understand. All of us have had tragedies of a loved one that we wrestle with. What's fair? What do you do to have a sense of justice in all of this? And so you have been placed on. You were sentenced in April of 21. So we're going on 5 years, I think, next year, right? And so you were sentenced, and then you were placed on probation in October of 21, which means that it'll be 6 years. It'll be 5 years in April, correct? From the time you were sentenced and put in prison. But on probations, this court, every one of them are unique and different. On probation, your stance is what?
Keep them inactive.
Why? Is that in the best interest of all concerned?
For the victim's family.
Yeah. Well, look, I don't have it before me. What the Victims' Rights Act has affirmative rights to the victims. What does it say in this circumstance? So, do we know?
They've had,
I don't have the act in front of me.
their rights are to be notified, to be heard, and but the decision is still up to the court. They cannot stop or start a plea bargain agreement.
Like Mr. Crenshaw, on representing your defendant, right now he is on. Is it an active or an inactive form of probation?
Inactive.
It's inactive.
He's been inactive since
So
the court came here, since we came to court in May.
What is
The
it
court
about?
said you were going to grant the motion, but you're going to place him on inactive status for 6 months, and we would come back at the end of the year. And we came back last week, and then he said he wanted to hear from the family, and then we came back to it.
Right. What is it about inactive probation that is interfering with his abilities to make a living?
The promotion does not allow the felon conviction. He would be enhanced to a supervisor role, and they do not allow the felony conviction. That's why when I filed the motion for early discharge, I requested the provision of judicial clemency, which would in essence have the same legal effect of changing this to a deferred. It would still remain on his record, but it would be the legal consequence of a felony deferred probation, which was originally his goal in this case. And after 2 years in custody and safety and everything else, I was hoping that he had demonstrated over the last 4 years that he has been
You're asking for termination of the probation as well as clemency.
As well as, in essence, yes, making this into a deferred. And that would allow him to begin the new job.
And the people, the family.
We're totally against both of them.
Puts me in an interesting spot, doesn't it? What does the family exactly want?
They wanted him to serve out his prison term, but if he didn't, they wanted him to serve out his probation term all the way to the
We
end.
don't have that right now.
Yes, sir.
So what is it they
They want him to serve out his probation term, and they don't want him getting judicial clemency at the end of all this. He was convicted. They want that conviction to stand.
Anything else? I'm gonna, at this point in time, I'm going like that. But their loss is far greater than yours.
Thank you, Judge.
That's it. All right. Dustin, Jawan Solar.
Oh, Judge, that was Lisette.
Tristan Jones, Thomas Kenneth.
On behalf of Mr. Kelly, Judge.
Ron Tristan. Hello. This is an announcement. What are we going to do, Tony?
Judge, Mr. Kelly's requesting 4 weeks reset. He's still working through discovery, and now that some more is on the case, I think that he's hoping to have conversations with her about, so if he could just have the reset.
All right. Yeah, this is over a year old.
I understand, Judge.
Yeah, I know, but when's something going to get done? Because I'm looking at home. Delay. It's been kind of something that this court just gets antsy over. To get that. I've looked. Ten settings. What are we going to do?
Unfortunately, Judge, I don't have a good answer in terms of timeline.
Oh, that's a good sign. It went in the trash. You know, Henry said this is, we can't open the door for that. That's faulty. Yeah, y'all had to have made a decision by that. Come on, I'll make the decision for you. Move over time. Darren Peace. 24 CR 1632. Darren Peace. And this one.
Mr. Kelly is requesting another 4 weeks on this case as well. He's still doing Mr. Middleton's movement is the knowledge that I have.
This one's kind of old. It's over a year old. Well, we'll stay. What do y'all say? There aren't as many resettings in this one.
Well, it's actually older than the other case, Judge.
I'm not sure how long Mr. Kelly's been. Again, Judge, I apologize. My knowledge is limited. I'm just here to come to him today.
Okay. I'm resetting this for 2 weeks. Okay. So Mr. Kelly can be here and talk to me.
Okay. Thank you.
Oh, thanks. Mr. Macon, Charles Amber.
Yeah, our Daniel is the prosecutor on this case, and I had a few questions asked him. I'd asked for 2 weeks till he's back and I can finalize everything. It'll be
2 weeks reset.
This one's much younger.
Maynard Torto.
You should have sent that plea on to that judge. I think it's ready. Should have.
What are they doing, Jasmine Young?
I've been speaking to Mr. Boyd about
Jasmine Young. Someone. Yeah. What are we doing?
Mr. Boyd and I have been speaking about the possibilities of this message. I don't know what that
You guys. Reset 2 weeks on Jasmine Young. Maynard.
Kind of resetting, and then I need to swear in just to sort of. He's done with.
Meanwhile, John West. Hey, Matt, Brent on Carlina Solomon.
We're working on that one. We're in ask for that.
Come on up, then.
Raise your right hand, swear or affirm have approved all three of the amendment of proof of you have.
On this one,
If your thumbprint,
criminal history on this.
place it
I
right.
didn't see it in the indictment. Just
Same one, place it right there. Okay, you put your hand in front of judge.
I'm up here.
We're just.
I'm sorry.
Awesome. Just grab this.
I won't say anything initially, Judge.
Can I make criminal history? What do you ask? Yeah. On this one?
TBC. I'm sure that has everything to do with the nature of this offense, Sharon.
Who is the victim? What's the relationship?
It's a person in Prince Hall. I don't think
They don't know. Yeah, no,
I don't think they're related at all.
and the victim is still vehement about moving forward.
This is not my case, this is Mr. Boyd, so I don't have that intimate knowledge.
Mr. Boyd was here. What would he say?
He would say dismissive.
No, he absolutely would not.
All right, you said you want to.
We're working on it still, but that.
Does he understand that she can't get in? I don't think she's eligible for probation in front of a jury with. I'm sorry, you interrupted me because it's aggravated assault. A deadly weapon is used. You can't get probation when a deadly weapon is by a juror.
We're still working on it, Jeff, but since Mr. Boyd's not here and we're at a currently in it.
You didn't know that, I bet.
Yeah, I told her that. But I can't get off the probation.
No, you can't receive probation from a jury. The only option they have is punishment for prison. But you can get probation on an agreement. But to a plea agreement. But a jury, I can give you probation, but a jury cannot. 3 weeks to think about this and talk about it. It's fine. 3 weeks. We get a recess. Here's the final and.
You want to handle Sorto, Judge?
Go to Sorto. 25 CR9.
Change.
They'd see on your. Maynard, sort of. President, Ms. McNally is here representing you. And does the defendant waive a formal reading of the indictment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about May 21st, 2025 in Jefferson County, Texas, you committed a third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? This is a third-degree felony, sir. This means that if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached, you would be pleading guilty, placed on deferred or unadjudicated probation. That can be up to 10 years in length. Fine $500. There would be terms and conditions of probation normal and customary for this type of offense. Is that your understanding of the agreement? If I follow this, you have no right of appeal. Do you understand? You have soft voice. She's going to take everything you said. How do you plead to this, guilty or not guilty? Yes. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes. Show you what marked as State's Exhibit 1. Did you sign this document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct? Yes, sir. State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freedom and voluntarily, man. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All proof so help you God.
So yes.
Yes, sir. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I'm going to follow this agreement. I'm going to find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand and appreciate the consequences of pleading guilty, even though there's sufficient evidence supporting a guilty plea from State's Exhibit 1 admitted to find you guilty of this felony offense. Instead, I'm going to follow this agreement and defer or postpone any finding of guilt so long as you follow these terms and conditions of probation. And you will be assessed a fine of $500. Other terms and conditions of probation, which are normal and customary, is the length of time is up to 10 years.
We're requesting 5, Judge.
Wow.
He has no criminal history of.
The objection,
No, Judge.
done, 5 years. And do well, a third, 1 2/3. And then you're a free bird. Okay. We're gonna, the probation office will prepare the documents, either sign, you will sign, and you will begin probation. Good.
He's good to see probation, Judge.
Yeah, see probation.
Thank you.
You want to throw somebody else? That's good.
I thought a little bit.
I'll have Judge make an excuse. Thank you.
Whatever happened to John West?
Let's hire Jason Nix yesterday. I think we were making sure.
Victor Martinez, where are you? Come forward.
So we can set it for an announcement for the next.
Here, go ahead.
Victor Martinez, you hired?
Yes.
You did, Mr. Nix?
Yeah.
Okay. He will be, he needs to get the papers into us so that it can show that's who's,
He told me he wasn't gonna be here today.
I think he's out of town or something, but something needs to be done. Otherwise, until that's done, nothing's changing. So what I want to do is in 2 weeks, I'm going to reset this for 2 weeks for a review to make sure this is done because we don't want to slip through the cracks. Okay. Get a reset then. Moses Green. Is it 2 cases?
Yeah.
What is this?
It's a bond reduction hearing.
I like it.
Deny, let's go on.
Where's the defendant?
He's in custody.
We need him out, right?
Yes.
Okay. What the bond right now?
I thought this was an announcement. Did you file for a bond hearing?
Yes.
Is there a reason why I didn't get a copy?
It was filed on 11/24, which is 2 weeks ago. And it says certificate of service. It was served on the district attorney's office through electronic filing method. Is that the way it's done?
That's
It
typically
just goes into the DA's office?
how it's done, Judge. Oftentimes, but I don't see.
I'll just start sending Musco to the defense project.
All right. So what are we going to do? 25 CR 951 and 952 Moses Green Sr. You were charged in 25 CR 951 with the first degree felony of aggravated sexual assault of a child younger than 14 years of age, but paragraphs 2 and 3 reflect that the defendant has two prior burglaries of habitation convictions out of the 252nd District Court. If found guilty of this first degree felony, and if the prior convictions were shown, you were looking at a minimum of 15 years in prison up to life imprisonment. Do you understand on that case? Yes.
Yes, sir.
25 CR 952, you were charged with the second degree felony of sexual assault of a child. Is it this before? Because the different names, but the first names are the same. There's the surnames are different. Is it the same child?
I believe it's the same channel.
Yes. Yes.
Playing catch up, chasing.
Judge, to be fair, I haven't seen either Mr. Ham or Ms. Monk on the service contact list. So it looks like it may not have been provided. Usually it goes to one, the other, or both.
Nonetheless, this, while it's here, this second case, 952, alleges a second-degree felony of sexual assault of a child younger than 17 years of age. And the same 2 prior convictions of burglaries are included. So this, if all of this was found true, you're looking at first-degree felony punishment in this case of no less than 5, no more than life imprisonment. So
Can I say?
2 life.
I'm sorry, John.
When you 2 life imprisonments are what you're looking at. What are his bonds right now?
So my understanding is that one is at 300,000, Judge. This is kind of strange. I can't see him on the inmate list. So, and I can't see an amount in the portal.
It's 300,000 on 951 and 200,000 on 952.
And so we're requesting reductions to 100,000 apiece, Judge.
Okay. Stay.
Judge, I feel like the amount that's set on this with his criminal history and the nature of these offenses is certainly reflective of what I've seen on bonds of these kind of cases. I would stand by with the safety of the community that the bond amounts are appropriate.
The court is looking at the circumstances of these cases. I've read the probable cause affidavit.
On the circumstance, on the circumstance matter, may we address?
Oh, hold on. I'm just telling setting forth the record. The court has reviewed the probable cause affidavits, the public safety report of the defendant, which reflects a rich criminal history that is not included in the indictments dating back to 2001, when the defendant would have been 14 years of age. Then that's odd. He was placed on probation for a year in 2001 for theft. Then 3 years later, about 3, just a little over 3 years, he's convicted of burglary of a habitation. Two burglaries of a habitation. 2005. Then it shows burglary of a building, convicted, 1 year confinement.
No felony conviction, Judge.
And then possession of marijuana, convicted. Driving while intoxicated, Class B conviction. Assault family member, 2010, convicted, 30 days. Assault family violence, 30 days. Conviction, class misdemeanor. Then criminal trespass, convicted, 10 days. Misdemeanor, evading arrest or detention in 2013, 60 days confinement. Failing, giving false information to officials, convicted. Assault of a probation, 10 years. Probation in 2013, and that expired. Evading arrest or detention in 2013, 60 days confinement. Resisting arrest in 2013, 60 days confinement. Failing to ID, the same kind of crimes that we're looking at a few years before. Then assault on a public servant, deferred, 3rd-degree felony, 2013. And then reckless driving. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 dispositions of probation or confinement, of offenses, of felonies and misdemeanors. And then now these two new cases have occurred. Anything else anybody wants to add?
Judge, on the indictment for the aggravated sexual assault of a child, December 31st of 2015 is listed as the date. And while the law certainly does not require the date to be exact, I did want to bring it to the court's attention that in October of 2015, on his probation, a warrant was issued. He went into custody shortly thereafter and was in custody. He then went from custody to safety. The court ordered him to serve in conjunction with that arrest a period of upfront confinement. And then he went to a substance abuse felony punishment facility, and he participated in the special needs continuum of care from January 8th of 2016 to September 27th of 2017. And so as far as the way the indictment is worded, obviously the defendant's position is that it wasn't possible for the offense to have been committed on or about the date listed. I think the court, in conjunction with the request for the bond reduction, if the court could just explain that aspect of the indictment, I believe.
I don't know. How can I explain that? I didn't write it.
When I say that aspect of the indictment, I mean the law as it pertains to the specificity of the date in the indictment and how.
The law does not require, but I think all the lawyers here know that. Yeah. And Mr. Wilkerson knows that. He deals with this all the time. The law provides that crimes can be alleged on or about a certain date, and on or about is a reasonable length of time. But generally, on or about has been by case decision to go back as far as up to the statute of limitations. So in a case like this is unlimited statute of limitations. So on or about probably has little meaning on this in these circumstances. So, but I've looked at the defendant's rich criminal history, probable cause affidavits in each of these cases, public safety report. This is a most disturbing set of circumstances of the victimization of a child, and if your request for reduction of bond is well presented but denied, this is set for trial, and we're fast tracking this. When can y'all be ready? It's got my attention. Whenever you're in trial. I'm not talking about the day or the next day, but we set it in 3 months.
That would work, Judge. I would like the opportunity
but
to.
Especially said, go ahead.
You know, I like to build a relationship with a child before they testify. So 3 months should work for me.
Special set for them. That is all. Anything else? We're in recess. Let's get ready for trial. Here's the best of it. Dennis, tell me when he's in, so we can. Now, we are about to go into trial on case involving sexual assault of a child, and that is by rule not YouTube. We will go online for YouTube when a disposition occurs, which may be today, and then there will be sentencing if convicted. So we're going to go dark.
Thank you.
One is here, so we'll try to get yours out as quick as we can. So let's start with Galena Katz. Pink. Ms. Katz, are you able to hear me?
Yes.
This is 25 BE 05949. This is a citation that was issued back on the 17th of November, 5 minutes to noon, in the area of 11 Mile and Woodward. You were cited for operating or holding an electronic device. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I admit with an explanation.
And what is that, please?
Well, I had my cell phone connected into my car, and I was on the speakerphone. And it was because my friend of mine had just gotten out of the hospital, and she asked me to pick up a prescription for her at CVS. And I was at the stoplight on the corner of actually 11 Mile and Coolidge. And at that point, I hesitated a little bit when the light turned green, because I was thinking, should I turn right into CVS and go through the drive-through for the prescription, or go straight? And that's when a car honked at me. I hesitated for like not even a second. And then that's when the police officer stopped me and said I was on the phone. But I wasn't actually even on the phone at that time. But before it was on speaker. It was hands-free on my speaker in the car. It was Bluetoothed into the car.
Observed you having it in your hand from 11 and Woodward to 11 and Coolidge.
It was on my console, on my armrest. It wasn't actually in my hand, because I wasn't using the phone. I was talking via Bluetooth.
Okay, well,
But it was sitting.
You rightly admit responsibility, I'm sure. There's no points for this with the Secretary of State. There is a substantial fine. It's $220, which can be paid online or by mail, or at the courthouse counter if that's more convenient for you.
Can I have it reduced?
No, that's what the fine is.
Okay, so it's just basically just a fine of $220. But
Yes.
is it illegal
No points.
Is it not legal to?
It's illegal to have your hand on it. You can't touch it.
Well, it was sitting on my armrest. I wasn't touching it at all.
The officer saw you, followed you because he saw it. He followed you from 11 in Woodward to 11 in Coolidge. When the light turned and you didn't proceed and waited long enough for cars to honk, that's when he made the stop. But he saw what he saw. And there's no points, but there is a fine, and it does need to be paid. Thank you.
Okay, thank you. And I can do it online?
Yes.
Okay.
Yes, you
All
can.
right.
Thank you.
All right.
And do we have Chandler yet? Yes. Terrence Chandler has come in since we've been speaking. This is 25 BE 05362. Mr. Chandler, you were cited on the 16th of October for operating a vehicle in Berkeley, 12 Mile and Tyler, and had expired plates. When did you get the plates or tabs renewed?
Sorry, give me 1 second. I apologize.
Do you have the new registration with you there?
Yes, I do. Yes, I do.
Okay. Can you put that in front of the camera?
Yes.
That's upside down.
Oh, sorry.
Back when I taught school, I could read upside down, but I've lost that.
Fair, that makes sense. So like, no, it doesn't.
That's better.
So I don't know how to mirror this. I apologize.
Would you read the, there's an 8-digit number in the bottom left-hand corner.
Okay.
There's more digits than that, but read the first 8 if you would.
Okay. It says 10/20/2025.
Thank you. And when you were stopped, the plates were expired.
Yes.
Your Honor.
Yes, sir.
I'd like to make a motion to just get rid of the citation for him.
Okay. Mr. Chandler, thanks to the officer's motion, this ticket is dismissed. You are good to go, sir. Have a good day.
Oh, okay. Thank you. Hope you have a good day.
You too.
Appreciate you.
Officer, thank you, sir. So Tyler, I think that does complete your docket.
All right, I appreciate it. You have a good day.
Thank you.
Thank you.
You too.
We have Officer Children. Do we have a person in the waiting room to be arraigned?
Yes.
And Mr. Howard, if you would turn on your camera, please.
Oh, I'll say out option.
Well, while you're working on that, I wanted to let you know that you're going to have the opportunity to consult privately with Attorney Manoogian before the arraignment. We're going to do that by means of a breakout room, which is a virtual conference room. The court is not a party to your conversation with the attorney. So you're going to see on your screen an invitation to join. You should be seeing it right about now. And Officer Childrey will meet you. Attorney Manoogian will meet you there. Either Attorney Manoogian. Where'd he go?
But the fact went to the breakout room.
I don't have him in the breakout.
He went to the waiting room. Hang on.
He get back in the week.
My camera on now? Yeah.
Yeah, the camera is okay, and you'll see on the screen an invitation to join.
Yeah, I see it.
Okay, join. All right. And you'll be meeting the attorney where you can speak in privacy with him. Mr. Pullman is for Officer Childrey. Mr. Pullman, please unmute yourself and turn on your camera. There we go. These are citations 25 BE 05447 and 5447A. The first ticket is for improper lane use. The second ticket is for unsafe start. These citations were issued on the 25th of October just after 10 o'clock in the evening in the city of Berkeley, Woodward, near Catalpa. You have a right to admit or to deny, or to admit with an explanation, either or both of these. As to the improper lane use citation, how do you wish to proceed?
I just want to start by saying I do take full responsibility for my actions. I'm sorry, say that again.
Are you taking responsibility for the infraction as cited?
Yes.
Okay, as to both of them?
Yes.
Okay, and what is your explanation, please?
I was unaware of my actions at the time.
How does one become unaware of what they're doing?
I guess I was just kind of, how would I say, just moving. I guess I wasn't really aware of what I was doing in the car at the time. It was my first time out the house in a while.
So I'll adjourn both out, and then once that, if that all gets through, then hopefully what they'll do is they'll assign Mr. Bird to your case or some other attorney. Okay, all right, thank you, sir. Fine, we'll continue. Thank you.
Thank you, thank you. See you at 4.
See what?
See you at 4.
Got a threat? All right. Court calls the case, View versus Brandy Graham.
She's in.
Oh, she's with him?
Well, she's in.
Oh. Assistant Public Defender Hannah Apple on behalf of Mr. Graham or Miss Graham. I think Miss Virgil is Graham here?
I haven't seen her today, but I did talk to her. Assistant Public Defender Chelsea Virgils on behalf of Brandy Graham. She definitely intended on being here today, Your Honor. Would you consider passing the case so I can call her?
I will not.
Okay.
Bench warrant will issue bond, $10,000, cash surety, that warrant will issue immediate. Thank you. Court calls the case, People versus Edward Gross.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Virgils with and on behalf of Edward Gross, who appears via Zoom. Mr. Gross, please state your name.
You're muted, sir.
Guess I couldn't read.
All right.
Edward Gross.
State your name. Thank you.
Yes,
Yeah,
sir.
we're asking to adjourn this. Mr. Gross had some very severe health complications, and I don't think he's in the right state to make a decision on this case.
January 8th, 2026, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Nicholas Harding.
Allen said on behalf of the people.
Assistant Public Defender Donnie Lee on behalf of Mr. Harding. Starting, could you state your name, sir?
Yes, Nicholas Harding.
And Your Honor, with regard to the PCC requesting an adjournment in order to have some plea discussions with regard to the bond, I would like to address the warrant and ask that it be recalled.
Go ahead.
Thank you, Your Honor. So with regard to the MIS test, verification of my understanding was provided to the court. Mr. Harding was hospitalized at the time. With regard to the new violation for the disorderly conduct allegation. I'm sorry?
On the 10th or on November 25th?
On the 10th, Your Honor.
What about November 25th?
November 20th is when I was arrested as a charge of disturbing peace.
Your Honor, he was hospitalized at that time,
yeah.
and I do have documentation to that effect.
From the 20th to
the 4th.
So he wasn't hospitalized on the 10th?
I was the 10th from the 17th. Yeah. I was at another.
Yes, and I believe, yes, my understanding is the documentation that was submitted by the previous attorney.
So is that why he didn't charge his battery?
No, Your Honor. So my understanding is that the new charge was disorderly conduct, and this arises out of a manic episode that Mr. Harding was suffering from. After his arrest, he was hospitalized for about 2 weeks.
When did he get out of the hospital?
On the 4th, Your Honor.
On the 4th of
December. Yes, he was
So why hasn't he charged his battery?
I've been charging it every day. I received notification, Your Honor, from Brian Levitt, who is my supervising agent, he said that he was no longer supervising my tether, but I took it upon myself to continue to charge it every day because I wanted to show the court that I was staying at 9270 Yorkshire Drive at my parents' residence, that I wasn't running away or up to anything bad. I've been calling into the drug testing line.
When did you last call into community correction?
I've been calling in since getting out of my behavioral health stay at the psychiatric unit. I've been calling every day since. Today is the only day I have yet to call the number. That the group number one is my.
When's the last time you talked to somebody at community correction?
Brett Levitt, which was probably less than a week ago. And I've been in contact with my probation officer and his assistant at this time out of 14A4, and they've been in the loop since the 24th. So my first hospitalization was the 10th through the 17th of November. And then I wasn't out. There was only 2 more days where my manic episode continued because that stay, they kept prescribing me the wrong medication. So at the first facility at Memorial Healthcare in Owasso, Michigan, they were prescribing me the drugs.
Were you at a hospital in Dearborn?
I went to that hospital second. That's where I was at the previous 2 weeks. Yes. And that's where I was inpatient for my bipolar. And that's where I was diagnosed with bipolar immediately when I got there.
And Your Honor, while he was hospitalized in Metropolitan Behavioral Health in Dearborn, he was given this new diagnosis. Additionally, he was given a new medication regimen, which he was stabilized on prior to discharge. And that includes 2 antipsychotics, 1 injectable, which he was not taking.
Gotcha. I'm not.
And in addition, I did see.
Call over and see, pass the matter and see if Mr. Levitt is at any contact with this individual before I make a decision.
Okay, thank you.
Have a seat.
Thank you, Your Honor.
Cause case versus Carlos Hicks.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Valinger on behalf of who approaches. Mr. Hicks, can you please state your name for the record?
Carlos Hicks.
And Your Honor, if the court recalls, last time Mr. Hicks said that he was going to be trying to find his own attorney, I believe through Ozone House. I'm not sure if he was able to do so. I did reach out yesterday to advise him to give me a call if he had changed his mind on that so we could discuss this case. We unfortunately were not able to discuss this case. I was not received a call back. So I would be asking for an adjournment on this matter because I just have had no client contact.
Are you getting an attorney?
Y'all, I'm just gonna switch my public defender.
You're gonna what?
Switch my public defender.
That's not an option.
It is. I don't know how you're gonna do that. Well, this is the person you need to talk to, so might as well talk to this person, because I don't think you're gonna get another attorney. I'll adjourn this out to December 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Or you could just have a permanent exam.
Is that what you want?
Yeah, I want a permanent exam.
To the best of my knowledge, Your Honor, the discovery is complete on this, and I will follow up with her to ensure that.
Preliminary examination, December 23rd, 2025, noon. Before me. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Barack Howell.
People. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Howell. Will you state your name for the record, Mr. Howell?
Hello, Derek Howell.
And Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Is that what we're doing?
Yes, Judge.
Plea sheet indicates that the defendant will be pleading no contest to the charge of 5th degree arson. the 1-year offense. Upon a successful plea to that charge, count 1 would be prosecutor and defendant. The prosecutor has agreed that they will recommend a sentence of no upfront jail. That's the court's full understanding of it.
That's correct, Judge.
All right, they have him sworn.
Right. Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth of God.
Yes.
State your name, please.
Derek Howell.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of arson in the 5th degree. Is that correct?
That is correct, sir.
All right, that's a misdemeanor. Punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property destroyed or the subject matter of the arson. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, sir.
All right. You understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
I understand that, sir.
All right. Understanding all of that, you still wish to plead no contest?
I plead no contest.
All right. Basis for the no contest plea.
Potential civil liability.
All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
I believe so, yes.
Oh, well, did you?
Yes, I did.
All right. Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I believe this will put me on probation.
Not at the time.
Not at the time.
Or at this time, right now, you're not on
Okay.
probation or parole, correct?
That is correct.
Yes.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily?
The voluntary.
All right. And of your own free will?
At my own free will, sir.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 3273-25. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense or actually a higher charge. Sir, I do have to advise you, if between the time that I accept this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that the judge, you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
And also the judge would not be bound by any sentence evaluation and or recommendation. You understand that?
You have to say yes.
I'm sorry, yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
The people are
Offense is
satisfied.
satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
January 26th at 9 a.m.
January 26, 2026, 9 a.m. before Judge Freshour. Bond in this matter will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case of the people versus Maya Hughes.
And good afternoon, Your Honor. Lori Yagi, Assistant Public Defender. I believe, okay, and Ms. Hughes, could you state your name for the court?
Maya Hughes.
Your Honor, now I'm double checking, but I believe we do have a conflict that is confirmed in this case. Let me just
But
verify.
we don't have an attorney assigned. It hasn't gotten over.
That's my understanding.
All right, Ms. Hughes, here's what I'm gonna do. I'm going to adjourn your probable cause conference out. You may get another attorney assigned to you in the case, okay?
Yes, sir.
All right, I'll adjourn it to January 8th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, ma'am. Court calls the case, People versus Ashiwan Jones Yankee.
People.
Assistant Public Defender Dobby Leva on behalf of Iowa Jones Yancey, Mr. Yancey. I did speak to Mr. Yancey yesterday. Unfortunately, I do not see him in the courtroom today.
Bench warrant will issue for defendant failure. Bond, $10,000, cash surety. And warrant will issue.
Thank you.
Court calls the case, People versus Gregory Jones.
People.
Assistant Public Defender, Your Honor, on behalf of Mr. Jones, who's approaching. Mr. Jones, state your name for the record, please.
Gregory Jones.
Judge, we're asking for an adjournment for outstanding discovery.
Probable cause conference will be adjourned to 2025, 9 a.m. Bond continue.
On the 30th.
Thank you.
Thank you, Judge.
Court calls case of the People versus Marcus Jones.
Assistant Public Defender, Chinazi Carey, I can really, Your Honor, on behalf of Mr. Marcus Jones, who is approaching, he's in the hallway, Judge.
Sure.
Yes, Judge.
Are you doing a Lebo look?
No.
Okay.
In the hallway.
That's not him.
That's not him.
That's him. You want me to make him the defendant?
Please don't.
No.
What? You sure?
Please.
Well, what'd you do with the client?
Well, Judge,
No, I'm not asking you. What'd you do with the client?
Your Honor.
They sent you out to look for the client. You came back empty.
Unfortunately.
Really? And you don't seem to care.
I am very, very upset about it too.
Judge, he's been in the hallway the entire day.
What?
He's been in the hallway the entire day.
Has he?
Yes, Judge.
He was?
Thank you, Mr. Allen.
I don't believe him either. No. But you don't know where he is?
I don't. I just walked right past him when I came in here just now.
See, because you stepped in, I'll pass it.
Thank you so much, Judge.
Fine, no, don't thank me, thank him. I was ready, I had the bench warrant sticker ready to go. Court calls the case, People versus Travis Kennard.
And on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kennard, who approaches.
And Mr. always has his plan. Well, there have been some days, but pretty much.
You know, we do our best.
Yes, that's it. Your name, sir?
Travis Kennard.
Thank you.
And Your Honor, we are just seeking an adjournment. My client's going to be providing some mitigation information in the next couple of weeks.
Gotcha. Probable cause conference, January 8th, 2026, 9 a.m. Bond continued. All right.
Thank you very much.
Sir.
All right.
Okay. So, court calls case of the People versus Travion Lewis.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Chinazi Carey, I can really, Your Honor, on behalf of Mr. Tavion Lewis. Thank you. Mr. Lewis, state your name for the record, please.
Thank you.
Judge, we are asking for an adjournment in this matter. The last time we were here, we adjourned for discovery. We have since received all the discovery. We just need to review it with our client.
January 8th, 2025, 26, 9 a.m. Bond.
Okay, thank you so much, Your Honor. All right.
Court calls the case of the people versus Asandu Lakaka.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Assistant Public Defender Davi Lebo for Mr. Lakaka, who appears via Zoom. Mr. Lakaka, could you please state your name, please, sir?
Osandu Likaka.
I have before me a plea form. Is that what we're doing?
It is, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of attempted possession of a loaded firearm in a vehicle to 1 year offense. On a successful plea to that, count 2, count 1 would be dismissed. There is an agreement that the prosecutor will recommend a sentence under the Home Truthful Trainee Act. That is the court's full understanding of the agreement.
That is correct, Your Honor.
Likewise.
All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
State your name for the record.
Osandu Likaka.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form or had one signed on your behalf by your attorney after going through it?
Yes, Your Honor.
Do you have any question regarding any of those rights?
No, Your Honor.
All right. Under paragraph 5, those are your rights which are part of a trial. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not currently, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
All right. And because you believe that you are indeed guilty?
Yes, Your Honor.
September 21st, 2025, at the location of Ellsworth Road near Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. Were you in a motor vehicle?
Yes, Your Honor.
Was there a pistol in the vehicle that was yours?
Yes, Your Honor.
Where was it located?
In the glove box, Your Honor.
All right. Did you have any authority and or legal permission to be able to carry the weapon in that manner?
No, Your Honor.
All right. Sir, if I accept your plea, I need you to understand that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that first of all, you would not be permitted to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. Do you understand that, sir?
Yes, Your Honor.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
The people are not, Your Honor.
All right, and has the court complied with the court rule?
It has, Your Honor.
The people are satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be January 14th, 2026, 9 a.m. That is before me.
Thank you, Your Honor. Should Mr. Lakaka contact probation?
Yes, January 14th, sir.
Thank you, Your Honor.
Bond continue. You need to contact our probation department. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Austin Lavastone.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Mr. Giles.
Assistant Public Defender Chelsea Vergils. Is this Austin Lobestall?
Yes.
With and on behalf of Austin Lobestall, Mr. Lobestall, please state your name.
Austin Lobestall.
Your Honor, I am asking for an adjournment in this case. I believe we do have a resolution. This was a case where the deal was contingent on paying restitution as bonds. We had to find a different resolution, and I think we have
Yes, you
found.
did. Have you found that, or?
I believe so, and he's ready to make a payment. So we're asking to adjourn for 2 weeks if possible.
Will that, okay, just so that I'm clear, will that satisfy if the payment's made, is that gonna satisfy, put the defendant in the same position that he thought he was in before whatever happened?
My understanding with Mr. Overwater is that once he makes the payment that he is about to make, the offer will be available for him to take at the next probable cause conference.
Good. I just don't want any defendants punished by what has transpired.
Thank you. Your Honor.
And he'll be able to do that when, I'm sorry.
Well, he can make the payment now. I believe Mr. Overwater suggested.
Well, no, because he's in court. What are you talking about?
Well, if we get December 30th.
Oh, so now you're picking your date. You know, that's fine.
I anticipate that he'll have to prepare a cashier's check, and then we'll have to submit an order modifying the terms of his bond to allow him to have contact with the victims in the case, narrowly tailored.
December 30th. Everybody can get that done by December 30th.
Thank you, Your Honor.
Thank you, Your Honor.
9 a.m. Bond continued. Thank you. Thank you, sir. Thank you. Court calls the case, People versus Khalid Mahmood, excuse me.
Cash spells to the people.
Keep writing me, I can't. It's an H, not an N.
How you doing, Jan?
I'm doing great. How you doing? Doing good, thank you. Great. Your name?
Khalid Mahmood.
Oh, one of them is white.
Hold on. Sometimes we're shocked that by calling their cases.
Oh, you're fine.
I apologize.
You're good.
Laura Yagi, Assistant Public Defender, Your Honor. I'm standing in on this case. And I did not fill out a green sheet, but I would request an adjournment for time to prepare with Mr. Mahmood.
All right. So you want an adjournment?
Yes, Your Honor.
All right. Why don't I do this? January 8th, 2026, 9 a.m.
Thank you, Jan.
Bond continue. You're welcome.
Thank you.
Court calls the case, People versus Hoffman. Homa? Homa?
And then on behalf of the people, Assistant Public Defender Chelsea Vergils with and on behalf of Othman Mahoma. Mr. Mahoma, please state your name.
Othman Muhammad.
Are asking to adjourn this probable cause conference, Your Honor, to review the discovery with Mr. Mahoma.
I am. He's got it. I will adjourn it out. I'll adjourn it out to the 23rd. Go ahead. As to the, December 23rd, 2025, 9 a.m. All right, as to the bond violation, do you have a copy of that?
I do, Your Honor. I did review it and spoke to my client about it. I believe that he would admit that he had contact with the complaining witness.
Is that correct, sir?
Yes, that's Your Honor.
All right. I'll accept that admission. What,
Your Honor,
anything you want to say on that? Because typically in these cases, I mean, this is a domestic, he's not to have contact, so.
So, Your Honor, I believe that the complaining witness is one of his few contacts in the area and that she reached out to him. He understands that that is not an excuse. I clarified his bond conditions. Mr. Muhammad struggles with some substance abuse issues that he is working on getting addressed by going to AA, taking Vivitrol through the University of Michigan. He wants to double down on that and look into additional outpatient treatment for both mental health and substance abuse. I think that Mr. Muhammad made a mistake. He understands now that, you know, inexcusable violation of his bond condition. I clarified how to follow that exactly. Well, I'm asking for him to stay out of custody and allow him to seek additional outpatient treatment.
Response.
Your Honor, I'm asking to be remanded. And the bond violation, the victim mentions that he was drunk and making a scene. He was in contact with her. This is a very serious strangulation case in which the victim had a dislodged tooth and redness around her throat from the strangulation. So I have concerns that not only is he with her, but she's saying he's also drinking. And I've concerned drinking causing scenes, violating court orders.
Defendant's bond based upon his admission. Defendant's bond is hereby ordered revoked. Defendant's remanded.
Would you allow release to inpatient?
Not at this time. Let's call the case of the people versus Mark Montgomery.
Ashley Feltus for the people.
Yes, Your Honor. Okay, thank you, sir.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Montgomery, who I believe introduced himself
Well, he
already.
didn't introduce himself. He just told me hello. Your name, sir? Mark Montgomery. Thank you.
Your Honor, at this time, there are no offers. We do have discovery, and so I believe we're requesting that this matter be set for preliminary examination.
People have their witnesses available the 23rd.
Can we potentially go to the next speaker, please?
Do you have any objection to that?
No, Your Honor. Mr. Montgomery, is that okay with you?
Can I hear you?
Mr. Montgomery, the court wants to go to December 30th for your exam. Is that okay?
Yes. Preliminary examination, December 30th, 2025. 9 a.m. That is before Judge Washington.
Thanks, Your Honor.
That is an in-person hearing. Okay. Bond will continue. Thank you.
Thank you.
Court calls case of the people versus David Najera.
Assistant Public Defender Jay Bellinger on behalf of Mr. Najera, who appears via Zoom. Mr. Najera, can you please state your name for the record?
Yes, David Najera.
And Your Honor, I have sent a rather comprehensive mitigation report to Mr. Mayfield, and I just want to give him time to read and consider that. So we'll be asking for a couple of weeks.
Slow. January 8th, 2026, 9 a.m.
It doesn't help that I put it in 8 font and single space.
Yeah, there we go. Thought I'd say that and then say something real quick that didn't give him a little chance to respond.
Thank you, Your Honor.
Thank you, Your Honor.
Who is that? Mr. Gills is asking me to talk? And the prosecutor, everybody? Nope, not doing it.
Oh.
Fine. Where's Virginia? Oh, there she is. You know, every PCC day causes me problems.
That's what I'm here for.
Okay, all right, fair enough, as long as we all know. Court recalls the case, People versus Brandy Graham.
Alexander on behalf of the people. Assistant Public Defender Chelsea Ridgefield. With and on behalf of Brandy Graham, please state your name.
Brandy Graham.
Thank you.
Your Honor, we would first ask to recall the warrant. I believe she was here the whole time, just right outside the courtroom.
I was in the wrong room.
I believe you. I knew you were here. I don't know what these other people were thinking. Okay, all right. Okay, I will recall the warrant.
Thank you, Your Honor. We are asking to adjourn the probable cause conference for discovery and address her bond conditions.
I'll adjourn the probable cause conference to December 30th. 2025, 9 a.m. Yes, that's the bond.
Your Honor, we're asking the court to consider allowing her to have contact with the complaining witness and to eliminate the no-go-to order. She is without a home due to these conditions.
She's what? I'm sorry.
She's without a home due to the current conditions. She was living with the complaining witness, who is her caregiver. She is working on getting an appointment with CMH. She identified she has a disability. So the complaining witness takes care of her, and if he is okay with it, we would ask to allow her to go home. And Your Honor, I do have a note saying that he would look into going somewhere else. However, I don't have confirmation that he's found another place to go. And at this time, I would object to them having contact or being at that residence.
So just so that I'm clear, is her resident
Who's on the lease?
and
We are both on the lease.
I'm sorry.
They're both on the lease.
Okay, they're both on the lease, but he happens to be your caregiver for certain issues.
Yes, sir.
Okay.
I don't have to say anything else.
And your understanding is that the other party may be going someplace else.
He said he would look into it for an alternative place. However, I don't have any confirmation that he's found an alternative place or is residing at an alternative place, only that he was looking.
Okay. Then at this time, I'm going to decline to change anything regarding your bond until such time as we can make sure that
I'll talk to you
if
next.
the place has been vacated, then we'll do something. At this
I
point,
understand.
your bond will continue with its current condition. Okay, thank you.
Your Honor. Step outside and talk.
Order. Got it. That's all that, okay. All right. Recalls the case, People versus Nicholas Harding.
Alexander, on behalf of the people.
Assistant Public Defender Don B. Leba on behalf of Mr. Harding. Harding, could you tell us what your name, sir?
Yes, Nicholas Harding.
I thought you had indicated to me you called over to community corrections,
I'm sorry.
that you had called over to community corrections,
The night of the second event, yes, there was a call to community corrections.
but did you call?
My mother and I called that evening that it was bad.
I don't have any indication. You've only talked to them via email.
Through community corrections.
Yeah.
So after I was released from Metropolitan Behavioral Health, they gave me a Washtenaw County Community Corrections, and I contacted them, and I had my first intake with them. And it was the second day I had gotten out, and I asked Washtenaw Community.
But I thought you said you had been going over there.
Through that place in itself, I have not quite gone there. I've been to numerous different institutions, the Metropolitan Behavioral.
But I thought you told me that you went there.
These are referring to community corrections. Oh, I'm sorry. Yeah.
Regarding your time.
I'm so sorry. Community corrections. Yes, I have been on probation this entire past year. So I've been going to community corrections. I'm sorry. I'm getting the two places mixed up. I have been going to community corrections on a weekly basis over the past year, and I've never tested dirty or negative or positive.
So are you going to community corrections on a different case?
Yes, now I believe it is. Yes.
What do you mean now you believe it?
I don't think, do you think you're on probation now?
I'm still on, I applied for early release several months ago, and I believe.
Okay, who's your judge on that case?
Anna Fresh Hour, and
Judge Fresh Hour.
Fresh Hour, yes, and my
newer person.
My probation agent in that court is Ted Heaton and his assistant Sandy, whom I've been in contact with regarding all of this as well.
Okay, so you've been counselor, do you know anything about that?
Your Honor, he did indicate to me he's been in ongoing communication with his with his probation agent in the 14A1 case, in the 14A4 case, I'm sorry, but I've not been in contact with them myself.
But is he going to community corrections on that case?
To the best of my knowledge, Your Honor.
Well, have you checked it?
I have not, Your Honor.
Sir, are you represented by the PD in that case?
No,
Who's representing you in the other case?
in my previous DUI case from a couple of years ago, that would have been another attorney that I haven't spoken with because we've gotten all of the things said and done and with my placement with early release. So I applied for early release from probation, and within a day or two of me getting off of the early probation is when this incident happened on November 4th.
And Your Honor, for our notes on at least the most recent case of 14 April, I don't have any notes of like a review hearing. As the last note I have on that case was from an APA, was from September. And then I don't have anything about reviews or, so I'm not sure.
The last time I saw my probation agent was probably 2 or 3 weeks ago in person. I went to his office regarding all of this.
So you went. Oh,
because they picked me up on.
So hold on a second. You got a violation hearing in front of Judge Freshauer in January, right?
That's correct.
Did you know that, counsel?
I did not, Your Honor.
So, and you had the violation hearing because you're not compliant with your probation. So you haven't been released from probation.
That was the confusion originally. So now I know that information.
Now you know what information?
Now I know that I'm no longer off of probation because when I got out.
When did you think you were off of probation?
I never assumed. I never wanted to assume I was off. So I'm saying for the last maybe month or so, it's been.
Is anybody here with you?
Yes, Your Honor.
Yeah,
His
my
parents
parents
are.
are.
His parents are both here.
What day do you have the violation here?
So it is on January 13th.
Okay. Before Judge Freshauer.
Your Honor, is that for the 2024 case? That's for 022.
All right. And all of that. Maybe it's Teller. Was that a home confinement? I can't. Smoking. Okay, so. Anything else for anybody?
Yes, Your Honor. I did want to indicate that he is on this new medication regimen. He indicated to me that when he was in jail previously, he was not.
I get all of that.
Thank you. Well, I would like to note then that we have no objection to a home confinement tether. He does have follow-up mental health appointments scheduled. Now that I am informed that he has the ongoing case, I can find out who his attorney is.
Well, why would I put him on a home confinement?
If the court had concerns regarding compliance and failure to appear.
It doesn't make any sense to me. Anything else from people?
Mayor, I just have the same concerns that the tether was not charged. He hasn't reported in and there was a positive THC and I'm not sure if he has a medical marijuana card that was provided.
Do you
I do
have a medical marijuana card?
I do, and I did provide it to community correction.
Okay, but let me ask you this. With your current medication regimen, are you supposed to be using marijuana?
Yes, if from my psychiatrist point of view, yes, I'm allowed it.
That you're allowed to. Mom and dad, is that correct?
Yes.
It is? Okay. All right, here's what I'm gonna do. All right, young man, normally I would remand him to custody. I'm not gonna do that in this case, but I'm also not gonna put him on something more restrictive. Because I think what transpired here was not he wasn't intentionally, I don't think, trying to do anything. And so young man, here's what I'm gonna do. I'm gonna put you, he admits to the violation of not charging his tether. Is that correct, counsel?
Absolutely, Your Honor.
All right.
But I wasn't.
So what I'm gonna do is I'm gonna send you back over to community corrections. Okay?
Okay.
You need to, did you give them back the tether?
No, I still
You still have it, Your Honor.
I've been charging it as well.
God bless you. Okay, look. Okay, go back over. I'm gonna put you back on the location tracking.
Okay.
Okay?
Thank you.
And you're welcome, young man. And and Mom, I saw you. You're welcome also. I'm going to tell you something, young man. And that is, I don't know your mother, but mothers are great people, right? Because a lot of times all they do is they just sit there and silently pray for the well-being of their children. And I could feel that from your mother back there. That's so.
Phenomenal woman.
Pardon?
She's a phenomenal woman. I'm very, very grateful to have had her as my mother. So thank you.
You know something, young man? Every day I wake up and I just always hope for a miracle and a blessing. And I think I just saw it because I love it when people give credit to their mothers for what they've done. Because sometimes there are a lot of people that just take it for granted. Okay. So what I'm going to do, we're going to prepare a new order. Okay.
Okay.
And you're going to need to go back over